Welcome to the final round of the 2020 Carrigan Cup competition, Colorado Law's premier student mock trial competition. Given its remote format, this is likely the most unique final round of the Carrigan Cup ever. Nonetheless, we expect today's final round to be as outstanding as always. This competition is made possible by the Carrigan Endowment, which was established by the generosity of Judge Jim Carrigan, his wife Beverly, and their children and friends. Michael Carrigan, one of our esteemed judges this year, was instrumental in establishing this competition in his father's honor. The Carrigan Endowment supports the annual Carrigan Cup competition, provides valuable financial awards to the student finalists, and supports the law school's mock trial team, which participates in a number of external mock trial competitions throughout the country each year. On behalf of the law school, I would like to thank the Carrigan family for their generous support of Colorado law. This last weekend, 12 teams, 24 student attorneys, competed in a series of mock trial rounds to select the two most outstanding teams. The finalists will showcase their skills for us during today's final round. The student finalists for this year's competition are 3L Tyler Smith and 2L Nick Steverson for the plaintiff, and 2L Peter Selimos and 2L Evan Smither for the defense. We thank the practitioners from the Denver-Boulder area who served as judges for the preliminary rounds of Carrigan Cup this past weekend. Thank you also to our mock trial president, Caitlin DeWolf, and our internal competition chair, Lindsay Floyd, for their hard and outstanding work in making today's final round possible. And thank you so much to our IT department for helping us live stream this event. Each year for the final round, we welcome a distinguished panel of judges. We are so honored to have three outstanding members of our legal community serving as judges today. Michael Carrigan, the proud son of Bev and Jim Carrigan, and a partner at Holland and Hart. The Honorable Melissa Hart from the Colorado Supreme Court. And John Purvis, a partner at Purvis Gray Thompson. We know that Judge Carrigan would be proud of the accomplishments of all of these students, and we sincerely thank the Carrigan family and friends for all of their wonderful support to Colorado law. Thank you.
Thank you, Emily. I appreciate it. And before we begin, what I'd like to do is to speak for a couple of minutes about my father, Jim Carrigan, for whom this competition is named, then briefly introduce myself and ask my fellow judges for the competition to introduce themselves. So Jim Carrigan did one of the greatest things for me before I was even born, which were two of the greatest things. One, marry my mother, and two, move to Colorado. He grew up the son of a baker without much education, and then he put himself through University of North Dakota Law School, and then undergrad and law school, and then he was doing graduate studies at NYU, where he met Bev Halpin, who became my mother, and was recruited to come to Denver by Justice Byron White to join a law firm, and instead he ended up teaching at DU. We often, although my dad was Catholic and he had 6 kids, we often said that the University of Colorado Law School was his 7th child. He loved this school. He taught at it, both as a full-time professor and then as a judge. He very much enjoyed his relationship with his students and hired quite a few law clerks out of CU Law. And he had a distinguished career, and much of it is represented by today's panel, because Jim Carrigan was a professor like Melissa Hart. He was a very successful plaintiff's attorney like John Purvis. He served on the CU Board of Regents like I did as well. And ultimately he was appointed to the federal district bench, where he served as a trial judge for over 16 years. And even during that time, he devoted a lot to CU Law. So this competition that I had the honor of judging with him at times was a very proud part of his legacy, and I'm delighted that my mother, Bev Carrigan, is joining us today. So briefly, my background, I went to CU Law, of course, the only law school I applied to. Loved it, even when it was at Fleming. And then went on, was a DA for 6 years, tried over 100 cases. And then after a short stint with a small law firm, spent a year volunteering in South America. And then I joined Holland & Hart, where I've been since 2003, and have continued my trial litigation practice there. So Justice Hart, would you like to introduce yourself?
All right, I'm the first unforced technological error of the night. Sorry. Thank you very much, Michael. First, I want to say thank you to CU for including me in this competition. One of my favorite things about doing anything that involves the Carrigans is that I get to see Bev. So Bev, I'm sorry I don't get to say hi to you. Hi. And one of the things that Michael didn't mention about his father is that Jim Carrigan also served on the Colorado Supreme Court. I think before he was a U.S. District Court judge.
Yes.
And I now serve on the Colorado Supreme Court, and I'm incredibly honored to follow in the footsteps of people like Jim Carrigan. He really was a hero in this legal community, and I think sort of a emblematic of what this legal community is in terms of its connectedness and its openness to working together. And it's one of the things that I loved when I was, as Michael mentioned, a CU law professor, which I was for about 18 years before I joined the Colorado Supreme Court, is this is the most tight-knit, welcoming, supportive, engaged community, legal community that I've ever been part of. And when I describe not just CU, but Colorado, when I describe it to my friends in other parts of the country, they just think I'm making it up. But I'm not, and it's clearly been true for generations, because everything I hear about Jim Carrigan, for whom this event is named, is that he was a perfect example of that as well. So I'm just really honored to be included in this. I'm particularly honored because apparently I did not know this, or I probably did from her resume, but the president of mock trial, Caitlin DeWolf, is externing for me right now. And it's just such a treat to see students that I still get to work with being involved in these things at CU. So thank you for including me.
Thank you, Justice Hart. John.
Hi, Michael. Following Justice Hart's lead, let me say hi to Bev. Hope all is well and hope to see you soon. My background is that I'm a member of the class of 67, which is not 1,000 years ago, but it's close. And when I had the luck of being there in law school at that time, I had the formative experience of being part of a group called the Assigned Counsel Program. There were 8 of us, and it was a Ford Foundation sponsored project to see if students working in league with appointed counsel from a local bar could be as effective as public defenders. And that project was invented by and headed up by none other than Jim Carrigan. So he has been with me my whole career and has been very important in various ways that I won't go into now. But it's an honor for me to be here and participate in this. After I graduated from law school, my first job was as a deputy public defender in Boulder. Then the electorate decided that my boss needed to get into a different line of work. So I was out of a job, and my second job was to go back to the law school, and I was the part-time assistant director, and then by default, the part-time director of the clinical program, which was then called the Legal Aid and Defender Program. I did that for a while, and then in 1969, the Colorado legislature started up the Colorado State Public Defender System, and I was hired to start and run the Boulder office of the Public Defender System beginning in January of 1970. I had a longtime friend and who's been my partner recently, Bill Gray. He and I were yet together with a wonderful person named Alice Hansen, who kept everything running. And we had some very fine experiences, one of which was developing a link with the law school so that we could, under the student practice rule, essentially have a constant stream of law students in our office, essentially as interns. And that, I think, has continued for many years. Whether it's still in place now, I don't know. And so after that, I went into private practice, small firm practice. And then to pass on, come back to the law school, I took a leave of absence at one point from my firm, and I taught a full-blown course of evidence at the law school, which was a daunting and terrifying experience, but I loved it. And I also taught advanced trial advocacy and trial advocacy for many years there. And I should mention that among my students as an evidence professor, quote unquote, was Sheila Carrigan. So that was a nice situation. So since then, in the middle of my career, the law school alumni board was kind enough to give me a Distinguished Achievement Award. And then last year, they were even more kind in giving me the Nouse Award. So that is my link to the University of Colorado Law School up to the moment.
That's a pretty good, strong ties. Thank you. Thank you, John. Well, terrific. I will be the presiding judge, and we will all do the best we can with objections, and I will certainly give you a little bit of extra time understanding the unusual circumstances we have here. So what I anticipate doing is we will probably take a short break at the half motion, but let me begin by calling the case. Then in the district court for Dallas County, the state of Lone Star, I will now call case number 14-033-971, Victoria Denning versus Zeta Lambda Nu Fraternity. Will counsel for the plaintiff please enter their appearance?
Yes, Your Honor. Nicholas Steverson for the plaintiff, along with my co-counsel, Mr. Tyler Smith.
Thank you. And for the defendant?
Yes, Your Honor. Peter Selimos with co-counsel Mr. Evan Smithers on behalf of the defendant.
Very good. Do we have any motions in limine? First for the plaintiff?
Yes, Your Honor, we do have motions in limine. We do have a few housekeeping problems if we would like to talk through those first.
Yes, please. Go ahead,
Okay.
Mr. Stevens.
For the objecting attorney, would you rather us leave our microphone on and just stay silent until we object, or turn our microphone on and off when we need to make an objection?
As long as you don't have a lot of background noise, I think it makes sense to leave it on. Thank you for asking.
Understood. May we have the jury instructions constructively read before closing arguments?
Yes.
And then lastly, the plaintiff would like to draw the court's attention to certain fact allegations admitted in the defendant's answer, which the defendant filed pursuant to Federal Rule Civil Procedure 8, and which is located on page 11 of your packet. For a bit of background, this is a wrongful death case related to a death at the defendant's fraternity house. As you can see, defendant admits paragraph 5 of plaintiff's complaint, as well as paragraph 13. Paragraph 5 of plaintiff's complaint, located on page 8 of your packet, reads that the defendant fraternity held a party on May 24th, 2019, that defendant's treasurer, Andrew Dornberg, organized that party, and that Mr. Dornberg repeatedly invited, quote, Ms. Denning to that party. Paragraph 13 also admits that at least while she was an invitee of that party, the fraternity owed her a duty of care. As such, the plaintiff just asked that the court take judicial notice of those admissions.
Notice taken. Thank you.
No further housekeeping motions from the plaintiff. I believe that the defense has a few.
Okay, thank you. I'll invite the defendant for any housekeeping matters before we start with the motions in limine.
Thank you, Your Honor. The defense has several housekeeping motions. The first being specific to the defense, we have already conferred with opposing counsel about the ability to stand up during this case, and we are. So they're cool with that. Next, we have the request to constructively approach and constructively publish, please.
Under the circumstances, I think that is warranted.
Thank you, Your Honor. We would next like to bring the court's attention to the case problem stipulations about exhibits 11 and 12. In your case problem packet, those are PDF pages 5 and 6, respectively. We would just like judicial notice on those two issues.
Judicial notice accepted. Thank you. Anything else housekeeping-wise?
Yes, Your Honor. Our witness, Courtney Perez, is being played by a 1L who is a man, so Courtney Perez would be a man.
Okay.
And final one is about the dates of trial. We've already agreed with opposing counsel to move the case problem year up to 2019, meaning that the party at issue occurred in 2019, and then trial is now being brought in 2020.
Makes sense. Thank you. All right. Well, we'll move to the motions in limine now.
Yes, Your Honor. And I'm sorry, I do have, I apologize for interrupting you, Your Honor. We do have a few substantive stipulations that we would also like to point out to the court.
Okay.
The parties have stipulated that any mention of Miss Kay Denning's bad standing at her sorority is inadmissible.
Okay.
The parties have stipulated that any mention of Chris Bloom's misdemeanor conviction for shoplifting is inadmissible.
All right.
And the parties have stipulated that Exhibit 14 in your packet on page 64 is also inadmissible.
Inadmissible?
Yes, Your Honor.
Okay. All right.
Shall I move to motion?
Ready for a motion limine?
Yes, Your Honor.
All right. Motions eliminated from the plaintiff.
The plaintiff moves in limine to exclude Exhibit 3 on page 47 of your packet as hearsay under Federal Rule of Evidence 802. For a bit of background, the defendant hosted a party on May 24th, 2019, where Ms. Denning, our decedent, sustained fatal injuries, and Exhibit 3 is a sign that the defendant fraternity allegedly hung up at, above their front door that night. The sign's a statement that only those over 21 are allowed into the party, which the defendant will offer to show that such a policy in fact existed. As such, Exhibit 3 is hearsay and should be excluded as such.
All right, response to the defense?
Yes, Your Honor. I do not believe that 802 is the applicable rule here because it would appear that the issue lies with 801, being that a hearsay statement is an out-of-court statement offered for the truth of the matter asserted. However, this isn't an assertion. This is a performative act. The act of hanging the sign is not being offered to prove, in fact, that the rule was that people under the age of 21 were not allowed into the party. The sign is being offered to prove that the fraternity, the defendant, took steps to give notice to people under the age of 21 that they are not invited. It's not about proving de facto that the rule of no one under 21 applies, Your Honor. So we think that it is not hearsay within 8011.
Response, Mr. Steverson?
Yes, Your Honor. The statement "must be 21 or older to enter," which is what the sign reads, I believe, is absolutely an assertion. Hearsay rules cover written assertions, and this is being offered to prove that that's in fact the case at the party. As to defendant's notice argument, I believe that's an effect on the listener argument. I don't believe that the defendant will be able to lay proper foundation that Ms. Denning actually saw this sign and thus was on notice that that the policy existed based on the sign. I also would note that, as noted in the answer, Mr. Dornberg, the fraternity's treasurer, repeatedly invited her. He mentioned no such policy.
Okay, well, thank you very much. Given the court's inclination to allow evidence so that the jury has a whole picture, I'm going to deny the request. Any other motions limiting?
Yes, Your Honor. The plaintiff moves for a pretrial ruling that Mr. Andrew Dornberg, the treasurer of the fraternity, and the man who organized the party on the night in question is an agent of the fraternity for purposes of FRE 801 D2D as an opposing party. Mr. Dornberg was acting in the scope of his agency throughout the night and made statements within the scope of that agency, including statements about how to plan the party, invitations to the party, and statements to the police about how the party unfolded. The plaintiff thus respectfully requests a ruling that Mr. Dornberg's statements within the scope of his agency, when offered by the plaintiff against the defendant, are opposing party statements under 801.
Response from the defense.
Yes, Your Honor. Admissions by agents and employees under 801 D2 require that the admission be within the scope of such employment or agency. Now, such inquiries are highly context specific. Our view is that a flirtatious text message sent to a complete stranger that has no reference to the fraternity that bestows agency upon Mr. Dornberg is just one example of several that you will see where Mr. Dornberg is not acting as an agent within the fraternity. We are not going to posture and pretend that he was not an agent of the fraternity, Your Honor, but we are asking for you to reserve ruling and deal with the issue contemporaneously once proper foundation has been laid. And just in furtherance of that, any plain meaning interpretation of treasurer does not include personal romantic interests and sexual attraction. And this is a repeated issue.
Even in a fraternity. Okay.
Excuse me, Your Honor.
Sorry. Anything further?
Yes, Your Honor. Ambiguity here should inure to our benefit, given the extreme prejudice that would come from arbitrarily and categorically choosing one interpretation over another when there are two equally reasonable meanings of whether agency is present or not.
Mr. Stevenson, will there be other bases for you to get these statements in?
Some statements, yes, Your Honor. I believe several will fall under the excited utterance rule. And
all right, then we'll take that up as a case by case.
That makes sense.
All right.
No further motions from the plaintiff, Your Honor.
Okay, thank you very much. Motions in limine from the defense.
Yes, Your Honor. We have one, and it is to respectfully move to exclude any mention of a particular incident that occurred at Zetaland Danu in the year of 1988. Opposing counsel has already stipulated that we can agree to exclude this information, and I forgot to bring it up, and I didn't want to just jump in, so I'm doing it now.
Is that correct, Mr. Stevenson? Have you agreed?
Yes, Your Honor. I would like to make one caveat to that, though, so that we're clear. The plaintiff agrees that any mention of a drowning at the fraternity 25 years ago is excludable under 403. However, there are circumstances within the case that suggest that Mr. Dornberg may have been on notice of this drowning. And in particular, there's one statement that we will seek to admit on page 56 of your packet. Mr. Dornberg was speaking to the police, and I'm sorry, I forgot to mention, Mr. Dornberg's father was a member of the fraternity when this drowning happened. While Mr. Dornberg was speaking to the police after the accident, he says, "We should have never built the lake or the beach. My dad warned me. I should have listened to him." We will seek to admit that statement, but we won't go into the 25-year-old incident or anything related to the prior drowning. We'll just use it as an instance of his foreseeability for the foreseeability element of proximate cause.
All right, very good. All right, why don't we commence with the proceedings then? I think we've addressed all the motions, is that right? Okay.
Plaintiff's already proceed, Your Honor.
Terrific. So my understanding is you will be keeping time on your own. I will be monitoring your time, and while we want you to use the time necessary to present your case, brevity is something that is rewarded in the scores frequently. So with that caveat, we'll invite opening statement from the plaintiff.
Plenty of booze, a rickety tower, and everything went wrong. Officer Bell arrives at the Zeta Lambda Nu fraternity house early in the morning on May 25th, 2019. As he looks across the front yard, he sees plastic cups and empty vodka bottles strewn about on the grass, a lifeguard chair rising from a makeshift pool of water, and next to that, a pile of sand meant to resemble a beach. On that sand, a young woman lies unconscious. Officer Bell soon learns that the young woman had climbed the lifeguard chair, fell into that shallow pool, and landed on her head, and died from that injury a few days later. That young woman was Kay Denning, a student at the University of Lone Star who had her whole life ahead of her. Members of the jury, the evidence you will see and hear during this trial will tell you a story of how the fraternity's carelessness led to Kay Denning falling from that lifeguard chair, causing injuries that ultimately took her life. You'll hear from Chris Bloom, Kay Denning's best friend. He'll tell you how earlier that evening he met up with Kay Denning here in Armadillo. How, as they walked through campus, they passed the Zeta Lambda Nu house, where the fraternity was busy preparing the elaborate beach party in their front yard. The fraternity made sure there was plenty of booze. A tiki bar and a pile of sand sat beside a wide, shallow pool, and inside that pool, a rickety lifeguard chair, Andrew Dornberg, the fraternity's treasurer, sat with a megaphone, shouting commands at his brothers. He spotted Kay Denning and, through his megaphone, asked if she would come to his fraternity party. Before Andrew Dornberg invited Kay, he didn't ask if she was old enough to drink. When she first arrived at the party a couple hours later, Courtney Perez, the party's bouncer, turned her away, but Andrew Dornberg kept in contact with her throughout the night. By the time she returned to the fraternity house a few hours later, Kay Denning had been drinking, but nobody was there to stop her from walking onto the house's lawn. She met with Andrew Dornberg outside for about 20 minutes. And eventually, Mr. Dornberg ran up to his room and left her alone outside. That's when she climbed onto that rickety lifeguard chair and fell off. Officer Bell arrived minutes later and began his investigation into the incident. During this trial, you'll hear about the few actions the fraternity took to keep the party safe that night, but listen for things that they should have done. Pay attention to the things that they didn't do to make sure that the party and the beach setup were reasonably safe. Members of the jury, nobody can undo the events of that night. Nothing can bring Kay Denning back to her family. But this trial offers you the opportunity to hold Zeta Lambda Nu accountable for their negligence. Negligence that, as the evidence will show you today, led to her tragic and untimely death. At the end of today's trial, my colleague, Nick Steverson, will ask you to find the Zeta Lambda Nu fraternity liable.
Thank you, Mr. Smith. An opening statement for the defendants.
Yes, Your Honor. Can everyone hear me loud and clear?
Yes, Mr. Smithers, thank you.
Your Honor, opposing counsel, members of the jury. It wasn't a diving board. It was simply a chair. Mr. Smith just told you all a story, a really sad story, a tragic one about a young college woman losing her life. He told you a story about the Zeta Lambda Nu fraternity and how they had a beach party and how Miss Denning got seriously hurt at the Zeta house, which ultimately led to her death. But Mr. Smith did not tell you the whole story. He left out some very important facts about the night of May 24th, 2019. First, he didn't tell you that Kay Denning was intoxicated that night. She had spent several hours at a different party, not on campus, not the Zeta Lambda Nu house. She was...
Smithers, you froze.
So Mr. Smithers is frozen. Can someone text him?
Your Honor, this may sound like a shock, but Mr. Smithers and I are in the same room, so I'm just going to have him walk over here.
You're killing your Wi-Fi. So yeah, switch places. That sounds good.
Thank you.
You're using too much Wi-Fi.
Mask up.
Okay, welcome back, Mr. Smithers.
Glad to be back. Unfortunately, I don't know when I froze, and this is kind of unprecedented for me, but what was the last thing you heard me say?
Well, I kind of got distracted because then you froze mid-sentence, but you were talking about several things that was not said in opening statement.
I believe they had not said that she was at an off-campus party.
Party and she was drunk and things like that.
You're right. I know where to proceed. Mr. Smith left out some key facts about the night of May 24th, 2019. Well, first, he didn't tell you that Kay Denning was intoxicated that night. She had spent several hours.
All right, carry on.
She had spent several hours at a
I just want to say we are not holding any of this against you because you're doing great. This is Zoom.
I appreciate it.
Don't be flustered. Go ahead.
Somber. She had spent several hours at a different party, off campus, not the Zeta Lambda Nu house. You will hear there she had several drinks, maybe a few shots, maybe even some marijuana. He also didn't tell you about the great lengths that the Zeta Lambda Nu fraternity took to ensure that every single guest at their party would be safe. The party was supposed to be fun, but as you will hear, it had to be safe. You'll hear that the Zeta brothers spent a great deal of time discussing the issues and how they could handle these problems that they may or may not have had. But most importantly, Mr. Smith tried to tell you that Miss Denning fell into the water. But the truth is, that just isn't true. She dove into that water. She dove straight into 3 feet of water head first. And that's why we're here today. Members of the jury, it was not a diving board. It was just a chair. My name is Evan Smithers, and I represent Zeta Lambda Nu fraternity today. You see, the plaintiff wants you to think that it was the fraternity's fault that Kay Denning is gone. That's why they brought the case. But that's simply not true. Zeta Lambda Nu is not the reason why Miss Denning is no longer here. And the facts you're about to hear will show you just that. Kay Denning did not fall in the water. She dove into it. Not off of a diving board, but off of a chair. Now, because the plaintiff brought this suit, they have the burden. And that simply just means that they have a job to do. They must prove to you 2 things. First, they have to show you that the Zeta Lambda Nu fraternity acted unreasonable, that they didn't take the proper steps to ensure safety. And second, they have to show you that some unreasonableness is what caused Kay to lose her life. Now, they won't be able to do this. They cannot meet this burden, as you'll hear today. You'll hear that Zeta Lambda Nu members took steps to make this party safe, secure for each and every guest they had. You'll also hear that it was Kay's decision to climb on top of the chair, to stand up there, and to dive into just 3 feet of water. It was not a diving board, it was just a chair. Now, because we believe Zeta Lambda Nu is not the cause of this tragedy, we also have a burden. We call this an affirmative defense. That means that it's our job to show you that it was a result of Miss Denning's decisions that led to her fatal injury. It was not Zeta Lambda Nu's fault. Let's talk about how we'll show that to you. First, you're going to hear from Andrew Dornberg. Now, as you heard earlier, he was the treasurer of the fraternity at the night of the party. He organized the setup, and he'll tell you that he never saw Miss Denning at that party. He'll tell you that she showed up after the party, but that they were quickly going to head out and go somewhere else. You heard Mr. Smith say that he went upstairs to change his shirt, but by the time he came back down, it was too late for Miss Denning. The next witness you'll hear from is Courtney Perez. Now, Courtney Perez was hired by the fraternity, hired to help set up the props, help check IDs, and to clean up after. Now, Courtney Perez will tell you about how he was at the front of the house the entire night, checking each and every single guest's ID and refusing the ones that didn't have an ID from getting into the house. And he'll tell you that Kay Denning did not have an ID and he did not let her into the house. We'll also talk about the precautions that they took with dealing with the props and how he was a bit worried about the chair at first when it was in the sand because he thought people might try to sit in it and he didn't want them to fall on the ground. We'll tell you that they decided to move the chair into the water and weigh it down to stabilize it with sandbags. And finally, he'll tell you about the accident. He'll tell you that he saw Kay Denning in the pool after the party was over, going to that chair, but he won't tell you that she sat in it. He'll tell you that she got to the top, she stood up, she put her hands over her head, and she jumped head first into just 3 feet of water. But members of the jury, that wasn't a diving board. It was just a chair. At the end of trial, my co-counsel, Mr. Selimos, is going to walk you through the facts, the evidence, and the testimony, and he'll show you exactly why this tragedy was not Zeta Lambda Nu's fault. You'll see that they didn't act unreasonable, that they didn't cause her accident. But the sad reality is that Miss Denning is gone. There's no bringing her back. But don't let the plaintiff take a terrible story and make it worse. This simply wasn't Zeta Lambda Nu's fault. And for that, we ask that you find the fraternity not liable.
Thank you, Ms. Smithers. All right, plaintiff, would you please call your first witness?
Your Honor, the plaintiff calls Mr. Chris Bloom.
Mr. Bloom, please approach the stand. Mr. Bloom, good evening. Would you please raise your right hand? Promise to tell the truth, the whole truth, and nothing but the truth.
Do.
Thank you. Please state your name for the record, and then Mr. Smith, you may commence your question.
My name is Chris Bloom.
Thank you.
Mr. Bloom, how are you involved in this case?
Well, I'm here because I was with Kay Denning on the night of the accident.
I want to talk about your relationship with Kay Denning. Did you know Kay?
Yeah, I knew Kay very well. We grew up together.
How would you describe your relationship with her?
Well, we were best friends since we were kids.
Let's focus on your background. How old are you, Mr. Bloom?
I am 21 years old.
Where do you live?
I live in Tall Tree here in Lone Star.
Are you a student?
I am, yeah.
Where do you go to school?
I'm a student at Tall Tree College.
Where did Kay go to school?
Kay attended the University of Lone Star.
How often did you and Kay see each other?
Well, I mean, even though we were at different schools, I would say pretty much as often as we could, being best friends, whenever time allowed, we saw each other.
I'm directing opposing counsel and the witness to page 63 of the case packet, Exhibit 13. Mr. Bloom, let me know when you're there.
Okay.
What is Exhibit 13?
That's a photo of Kay. I recognize it because I was in the picture, but it looks like I was cropped out.
Is this a fair and accurate representation of how Kay Denning looked at the time of her death?
I would say so, yes.
Your Honor, the plaintiff moves to admit Exhibit 13 into evidence and constructively publish to the jury.
Any objection for the defense?
No objection, Your Honor.
Exhibit 13 is admitted. Taken, constructively published.
Mr. Bloom, I want to talk about the evening of May 24th, 2019. Where were you on that evening?
That evening I went to the University of Lone Star, their campus in Armadillo, to see Kay.
When you first met with Kay, what did you and Kay do?
So when we first got there, I think it was like 4-ish, we went to, just had dinner at a Mexican restaurant, and then after that we went to find a place to hang out.
Where did you go to hang out after dinner?
After dinner we walked around, we ended up walking by the Zeta Lambda Nu fraternity house.
I want to talk about what you saw at the Zeta Lambda Nu house. So what did you observe as you walked by the house?
So as I walked by, they had some sort of beach that was set up out in the yard. There was a tiki bar, and there was a pile of sand that was supposed to look like a beach. And next to the sand, there was a shallow pool that was made out of sandbags, and then there was a lifeguard chair in the water too.
Was anybody outside at this beach setup?
Yeah, there were a few guys that were floating on rafts there, and there was a guy sitting on the top of the megaphone, or on the top of the lifeguard chair with a megaphone and a beer. That guy had his shirt off, and he was yelling at everyone with the megaphone.
Who was sitting on the lifeguard chair?
I didn't know at the time, but I later learned it was Andrew Dornberg.
I'm directing opposing counsel and the witness to pages 48, 49, and 50 in the case packet, exhibits 4, 5, and 6. Mr. Bloom, let me know when you've reached those pages.
Okay.
Mr. Bloom, what are exhibits 4, 5, and 6?
Exhibit 4 is the tiki bar that I saw in the front yard. 5 is the lifeguard chair, and then 6 is the megaphone that Andrew Dornberg was holding.
Are these fair and accurate representations of those items as you saw them on May 24th, 2019?
Yeah, they are.
Your Honor, the plaintiff moves to admit exhibits 4, 5, and 6 into evidence and constructively published to the jury.
Any objection from the defense?
No objections, Your Honor.
Exhibits 4, 5, and 6 are admitted and constructively published to the jury.
Mr. Bloom, I want to speak briefly about the lifeguard chair. Where was the chair positioned in relation to the pool?
So the chair was at the edge of the pool, and it was sitting in the water, so you couldn't really see the bottom part of the chair.
How deep into the water did the chair appear to be sitting?
It looked like maybe the bottom rung or two were submerged.
I want to talk about what happened after you first arrived at the house. So after you saw the makeshift beach, what happened next?
Andrew shouted at us with a megaphone as we walked by, and he said, "Hey, you in the pink shirt, you gonna come to my party tonight?"
Who was wearing a pink shirt?
That Kay was wearing a pink shirt. He was yelling at Kay.
What happened after Mr. Dornberg invited Kay to the party?
Well, after that, we just walked over to the pool, and Andrew came down to talk to us. And I remember on the way down, he slipped and spilled his beer. And then he just walked over through the water toward us.
As Mr. Dornberg walked through the water, how deep did it appear to be?
It looked like it was about 2 feet deep.
What happened after you talked to Andrew Dornberg?
Well, it was just kind of some small talk, and he asked for Kay's number. He gave Kay his phone.
Sorry, was there an objection?
Yes, Your Honor. Hearsay.
Hearsay. Response, Mr. Smith?
Your Honor, 801 D2D, Mr. Dornberg is acting in his capacity as an agent at that moment.
As an offer of proof, what would the response be from Mr. Bloom?
Your Honor, if I may constructively approach, I
Yes.
do not believe that they have laid any foundation to establish that he is acting within his representative capacity as a member of the fraternity when he is asking for the number of a girl that he was speaking with.
Okay, we are constructively at the bench, and I will say, Mr. Smith, why don't you lay a little more foundation to establish the relationship between the witness and the defendant? Pardon me, not the witness, but the declarant and the defendant.
Your Honor, may I respond to Mr. Smithers?
Sure.
Your Honor, we've just heard that Mr. Dornberg was up on the lifeguard chair shouting commands at the other fraternity brothers, setting up this beach party. As somebody walks by the party that he's busy planning, he makes an invitation to her. clearly within the scope of his duties as an officer of the fraternity.
Did you establish that he's an officer of the fraternity?
Your Honor, if I we'll hear evidence later on in the plaintiff's case in chief that, in fact, Mr. Dornberg was the head organizer of this party. And furthermore, it's admitted in the complaint.
Mr. Smithers, is it disputed that he's an officer of the fraternity?
No, it is not disputed that he's an officer of the fraternity. My issue with this is that he can invite her to the party as an officer, but once the conversation then turns to asking for her number, communicating about other things, that's when it reaches beyond the scope of his relationship with Zeta Lambda Nu.
Thank you. Well, as I understand the facts, it's alleged that he is an integral part of the negligence theory of the plaintiff, so I will allow this statement under 80D12. Go ahead, Mr. Smith. Re-ask your question.
Mr. Bloom, I'll ask that again. What happened after you first talked to Andrew Dornberg?
After we talked to Andrew, he asked for Kay's number, and he gave Kay his phone. She put her number in his phone, and then she gave me his phone, and I put my phone number in as well. And we parted ways, and we went back to Kay's sorority house for a little while.
I want to talk about what happened after you stopped by the sorority house. So after you went to the sorority house, where did you go next?
So after we left the sorority, we tried to go to the Zeta Lambda Nu party. And when we got to the door, we couldn't get in because we were both only 20 years old.
How did you know that you wouldn't be able to get in?
Well, there was someone at the door that was checking IDs, and they turned us away.
So after the person at the door turned you away, where did you go?
Well, we decided to go to a different party. There were a lot of parties on campus. So we went down the street to an apartment and spent most of our time there. It was an apartment that was near the Zeta house.
What did you do at that party?
Just hung out and had a couple drinks there.
How many drinks did you have?
I don't remember exactly, but not many. I'm not a big drinker.
How many drinks did Kay have?
Well, I wasn't with her the whole time, but I would say probably 3 or 4 vodka cranberries there.
Was she doing anything else while she was at the party?
Yeah, she was on her phone an awful lot there texting someone, and I eventually lost track of her.
What did you do after you lost track of her?
Well, at that point, I was worried that she would be trying to go back to the Zeta house, so I texted Andrew Dornberg to tell him I was worried she might be in bad shape.
Did Mr. Dornberg ever respond to your texts?
Yeah, he did eventually, but it wasn't until after Kay had died.
What did that text message say?
His message said, "I'm so sorry, all my fault."
Hearsay?
Objection is hearsay. Mr. Smith, response?
Your Honor, 801 D2D again, if we may constructively approach.
We're constructively at the bench. Go ahead, Mr. Smith. 801 D2 is the response, Mr. Smithers.
Yes, Your Honor. As we heard the witness say, this was days after the party that Mr. Dornberg organized. They have laid no foundation that shows that he is within the scope of his representative capacity at the fraternity. This is just a statement that he has said to Miss Bloom outside of his acting duties as treasurer.
Mr. Smith, is it offered for the proof of the matter asserted?
Your Honor, if I may make an offer of proof.
Yes.
The text message reads, "I'm so sorry, all my fault." This is the only text message that Andrew Dornberg sent Chris Bloom after a series of frantic text messages sent by Chris Bloom on the night of the incident. This text message was sent by Andrew Dornberg immediately after Kay Denning passed away. It is referencing clearly the incidents of the party that Mr. Dornberg planned as the head organizer and as an officer of the fraternity. So
Will Mr. Dornberg be a witness in this case?
Yes, sir. Well,
all right. Then I will sustain the objection, allow you to ask him while he testifies.
Yes, sir.
Objection sustained.
Your Honor, should I move to strike any sustained objection testimony, or should we assume it's constructive?
It's constructively striked.
Yes, Your Honor.
Constructively stricken out. Go ahead, Mr. Smith.
Mr. Bloom, after Kay Denning went missing, where did you go?
Yeah, I went to try to find her right away at the Zeta house. I got a little bit turned around, but I went there as fast as I could.
What happened when you first arrived back at the Zeta New house?
Well, when I first got there, I saw that Kay was climbing the lifeguard chair, and I started running right when I saw her, and it all just seemed like it was in slow motion. But she got to the top of the chair, and she stood up and wobbled around, and then she fell headfirst into the water.
What happened next?
Well, by the time I got to the pool to help, the door guy was already in the water, and Andrew was going out to help, and I couldn't even move. I just stood there. Then I remember also Andrew was yelling like, "She's okay, she's okay."
You mentioned that Andrew Dornberg was running out to help when you got to the pool. Where was Mr. Dornberg when he first arrived at the house?
When I first got there, he was running out of the house with a pitcher of beer in his hand.
No further questions at this time.
Thank you, Mr. Smith. Cross-examination for the defense.
Yes, Your Honor. I'll proceed. Mr. Bloom, I have some things I'd like to discuss with you. Now, given the nature of this cross-examination, please let me know if there's any technical difficulties I need to be aware of. I'd like to begin by talking about when you first went to the Zeta Lambda Nu house before the party began. There is where you met Mr. Dornberg, right?
When we walked by after dinner, yeah, that's when I first met Andrew Dornberg.
Came over and talked to you and Kay?
Yeah, we went over to the side of the pool, and he came over to us too.
But it seemed like he was just talking over you.
Yeah, he was definitely interested in Kay.
It was like you weren't even there.
Pretty much, yeah.
He really ticked you off.
Yeah, and he was definitely being a jerk.
That's right, you thought he was kind of a jerk.
Yeah.
Yet you still gave him your number.
Yeah, Kay just handed me his phone, so I put it in.
This was the first time you ever met him.
Yeah.
And when you saw him come over to you, he was on top of the lifeguard chair, right?
That's right.
And you stated on direct examination that he kind of slipped when he was coming down.
Yeah.
But he didn't appear hurt when he came and talked to you and asked for your number.
Not that I noticed, no.
Now I'd like to talk about after your meeting with Mr. Dornberg. You and Kay went back to her sorority house, which is where she lived.
That's right.
And in Kay's room, you saw an invitation.
I did.
Would you recognize a copy of that invitation if I were to show it to you today?
I likely would, yeah.
Your Honor, I would like to direct the court's attention, as well as opposing counsel, to Exhibit 1, which is on page 45 of the PDF file.
All right.
Mr. Bloom, would you let me know if you have that in front of you?
Yeah, 1 second, please. Okay.
What is that document?
That's the invitation.
And it's fair and accurate?
Yeah.
It's exactly how you saw it in Kay's room?
As far as I remember, yes.
At this time, Your Honor, the defense moves to enter Exhibit 1 into evidence.
Any objection from the plaintiff?
No objection, Your Honor.
All right, Exhibit 1 is admitted and constructively published to the jury.
Mr. Bloom, this invitation says it had to be 21, right?
Can you repeat that, please?
This invitation says that you had to be legally allowed to drink to be invited to the party, right? I'm sorry, am I frozen?
No, you're not. Sorry, I just was looking back to it. Yeah. Oh, do you want to repeat that? That'd be better. Sorry.
Mr. Bloom, the invitation says that you have to be legally allowed to drink in order to attend the party.
Yeah, it says old enough to drink, yes.
And the legal drinking age is 21?
Yeah.
Now, at the time of this party, you were 20.
That's right.
Kay Dinning was also 20. So neither of you were legally allowed to drink.
Mr. Bloom, please answer in the affirmative verbally instead of just a nod. Thank you.
Sorry. Yes.
But you two went to the Zeta house anyway.
Yes, we did.
You also saw a sign by the door.
Can you repeat that, please? Your audio is cutting out a little bit.
I think you're not muted. I'm sorry, Mr. Bloom. When you went to the house, you saw a sign above the door.
Yes.
And that sign said, must be 21 to enter.
As far as I can remember, yeah.
And yet you still waited in line to get in.
Yeah.
When you got to the front door, there was someone checking IDs.
Yes.
But you didn't have an ID.
No.
Kay Dinning didn't have an ID.
No.
So you weren't able to get in.
That's right. Yeah, we got turned away at the door.
So you and Kay left.
Yeah.
I'd like to talk about what you did when you left that party. You actually went to another party.
Yeah, we did.
And this party was off campus?
Yeah, it was down the street. I don't know of the official status of on or off, but yeah, it's down the street from the fraternity.
But it was at an apartment?
That's right.
Not the Zeta Lambda new house.
No.
Nobody was checking IDs there.
No, they weren't.
And Kay was with you when you got to this party?
She was?
And Kay was drinking at the party.
Yes.
Now, you think she might have had 3 or 4 vodka cranberries?
Yeah, probably, as far as I can remember.
Maybe even a couple shots?
Objection, speculation.
Objection is speculation.
Yes, Your Honor.
Response?
Your Honor, the witness can testify to what he knows and what he saw.
Objection overruled. Please state the question, please.
Mr. Bloom, she may have had a couple shots.
Maybe.
She may have also consumed marijuana.
Yeah, maybe. I don't know.
Now, you arrived at this party a little after 10?
Yeah,
And you stayed until about 1 a.m.
just about, yeah.
I'd like to talk about what happened when you eventually left a little after 1 a.m. Mr. Bloom, was Kay with you when you left?
No, I was trying to find her when I left.
And you went looking for her at the Zeta house, right?
Yeah, I was worried that she was going to go try to find Andrew, so I went there.
When you got back to the Zeta house, you actually saw her.
Yeah.
Now, I want to be very clear about what you saw. She was climbing the lifeguard chair.
Yeah.
And this chair was in the water.
Yes.
And you saw her get to the top of the chair.
Yes.
And then she stood up in the chair.
That's right.
And then she wobbled around.
Yes.
And that's when she fell in the water.
Yes, that's when she fell in the water.
But she didn't fall in feet first.
No.
Didn't fall backwards.
I don't believe so, no.
She fell head first.
Yes.
Thank you, Mr. Bloom. I have nothing further from this witness.
Thank you. Redirect, Mr. Smith.
Yes, Your Honor. Mr. Bloom, how much alcohol did you personally observe Ms. Denning consume at the apartment?
I think 3 or 4 vodka cranberries there.
No further questions. May this witness be excused?
Yes. Mr. Bloom, thank you for your testimony. You're released.
Thank you.
Next witness for the plaintiff.
Yes, Your Honor. The plaintiff calls Sergeant Alex Bell to the stand.
Sergeant Bell, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your full name for the record. And Mr. Steverson, you can commence your question.
My name is Alexander Bell.
Thank you.
Excuse me. Good evening, Sergeant Bell. I'd like to first give the jury a chance to get to know a bit about you. Where are you employed?
I'm a sergeant with the University of Lone Star Police Department.
And how long have you worked for the police department?
Ever since I graduated college. I'm 52 now, so about 30 years.
What training do you have as a police officer?
Well, I received a certificate from the Lone Star Ranger School, and I also have 30 years of on-the-job training.
And what does your job at the university entail?
I investigate all sorts of offenses, but primarily alcohol-related incidents. I also investigate petty crime, car accidents, fights, things of that sort.
Sergeant Bell, I'd like to turn to the events of May 25th, 2019. Do you remember the early morning of May 25th, 2019?
Yes, absolutely. I'll never forget that night.
Why won't you ever forget it?
Because that was the night of the accident at the Zeta Lambda Nu fraternity, and I'll never forget finding that poor girl Kay Denning unconscious at that party.
Well, I want to hear about Miss Denning, but first, how did you become involved in this matter?
Police dispatch sent me to investigate an accident at Zeta Lambda Nu fraternity around 1:55 a.m. that morning, so I flipped on my siren and I raced over.
What did you see when you arrived at the fraternity?
Well, when I pulled up, I could see that there were solo cups strewn everywhere, empty vodka bottles and rum bottles on the lawn. There was a tiki bar sitting out. You could smell the alcohol in the air, so there had obviously been a huge party.
What else did you see?
Well, I could see that someone had built a fake beach on the lawn. It looked like someone had built a crude shallow pool with a sandy beach, and a lifeguard stand was set up next to it.
What happened next after you saw the beach and the pool?
Then I saw the body.
What body?
Well, there was a group of people huddled around something on the sand, so I went over to see that it was a young woman. She was soaking wet, she was unconscious. I later learned that she was Miss Kay Denning.
Sergeant, I'm directing you and opposing counsel to turn to the previously admitted Exhibit 13 at page 63 in your packet. Would you let me know when you're there?
Yes, I'm there.
Do you recognize the person depicted in Exhibit 13?
Yes, this is Kay Denning, the girl that I found unconscious that evening.
And what did you do when you saw Miss Denning unconscious?
I immediately checked to see if she was breathing.
Was she?
Yes, but barely. So I secured the scene and an ambulance arrived seconds after that.
What did you do when the ambulance arrived?
I helped to load Miss Denning into the ambulance as quickly as possible, and then it raced off to the hospital.
Do you know what happened when the ambulance arrived at the hospital?
Yes, I do.
How do you know?
I later collected an autopsy report as part of my investigation and learned from that report.
Sergeant Bell, I'm directing you to turn, I'm directing you and opposing counsel to turn to Exhibit 11. This is located on page 59 of your packet. Would you let me know when you're there?
Yes, I'm there.
Do you recognize Exhibit 11?
This is the autopsy report for Miss Kay Denning that I collected in the course of my investigation.
Do you know who prepared Exhibit 11?
Yes, the doctors who examined Miss Denning's body.
And is Exhibit 11 a fair and accurate copy of that report?
Yes, it is.
At this time, the plaintiff moves to admit Exhibit 11 into evidence.
Objection from the defense.
None, Your Honor. This is also one of the exhibits that's been stipulated to, sir.
Thank you. Exhibit 11 has been admitted by stipulation and has been constructively published to the jury.
Sergeant, what happened when Miss Denning arrived at the hospital?
That poor girl was brain dead by the time that they got there, and she died 6 days later.
Well, now that we've heard how you found Miss Denning unconscious at the fraternity, I'd like to turn to what you did after the ambulance left. What did you do after the ambulance left?
I began my investigation as soon as the ambulance doors closed.
How did you start your investigation?
Well, I started by interviewing witnesses and compiling a police report.
Who did you interview first that night?
I began by interviewing Mr. Andrew Dornberg.
Who is Andrew Dornberg?
He was present at the scene. He was also the treasurer of the Zeta Lambda Nu fraternity at the time, and he had organized the party that evening.
What were your initial impressions about Mr. Dornberg?
Well, I could smell alcohol on his breath. His eyes were glazed over. He was slurring his words. He had trouble balancing. I could tell he was drunk.
What else could you notice about Mr. Dornberg's demeanor?
Well, he seemed incredibly upset.
How could you tell that he was so upset?
His speech was rambling. He seemed hysterical. At one point, he even started crying.
Did Mr. Dornberg say anything while he was so upset?
Yes, he did.
What did Mr. Dornberg say while he was so upset?
He told me that he and Miss Denning had been drinking together and decided that Miss Denning would try to do a cannonball.
Hearsay. 8011, Your Honor.
Response?
Yes, Your Honor. Firstly, 801 D2D. We've heard testimony that Mr. Dornberg was an officer of the fraternity and had organized the party. He's speaking to a police officer about what unfolded at that party. As such, he's an agent speaking within his agency. Otherwise, 8032, excited utterance. We've heard testimony that Mr. Dornberg was hysterical. These are statements he gave while he was hysterical.
Your Honor, if I may be heard.
Yes, we are constructively at the bench.
Your Honor, as far as, I'm sorry, let's begin first with the excited utterance. Under the excited utterance standard, an immediacy prong exists, and I have not heard sufficient foundation to know that the excitement that Mr. Dornberg felt was still what he was dealing with when Sergeant Bell interviewed him, because I do not even know which witness was interviewed first. So for all we know, Sergeant Bell could have sequestered these witnesses, interviewed them in an order that is not beginning with Mr. Andrew Dornberg, and then we could be trying to justify this hearsay and totally glossing over the immediacy prong. And in regards to 801 D2D, as the facts will show, the party ended promptly at 1 in the morning. And Sergeant Bell, you just heard, testified that Sergeant Bell arrived at least after 1:30, which is when the dispatch call came in. So I would make an argument to this court that the conditional status of Mr. Dornberg's agency ended once the party did.
A brief response, Mr. Stevenson?
Yes, Your Honor. As far as excited utterance occurs, Mr. Dornberg had just seen a woman fall headfirst into a shallow pool, and I believe it's a fair inference to say that he is still startled by that event when he's speaking to a police officer soon afterwards. Additionally, even if the party is ended, which the plaintiff is not conceding, Mr. Dornberg is speaking about events that unfolded at the party. As such, this is within his agency.
The court will overrule the objection, believes that there is a sufficient factual basis for both excited utterance and does not draw the temporal line with the agency as suggested by the defense. You may proceed.
Sergeant, I'll ask my question again. What did Mr. Dornberg say while he was so upset?
Well, he told me that he and Miss Denning had been drinking together all evening, or later that evening, and decided that Miss Denning would try to do a cannonball off of the top of the lifeguard stand. She then fell headfirst into the pool.
Did you ever try and contact Mr. Dornberg again after that night?
I tried to interview him again the next day, but he had refused.
Who else did you interview after Mr. Dornberg?
I interviewed Courtney Perez as well as Chris Bloom.
What were your impressions of Chris Bloom?
Bloom was completely hysterical over Miss Denning's accident as well.
And did Mr. Bloom say anything while he was so hysterical?
Yes, he did.
What did Mr. Bloom say while he was so hysterical?
He said that he was a friend of Miss Denning's, and the last that he had saw Miss Denning fall off the lifeguard stand headfirst into the shallow pool. He also said that Miss Denning had been drinking, but that the accident was all Andrew Dornberg's fault.
Did you speak to anyone else besides those three witnesses?
I canvassed other witnesses at the scene, but none of them had any information about what had happened to Miss Denning.
Well, since we've heard about the interviews you conducted at the scene of Miss Denning's injuries, let's discuss the police report that you compiled about that night. What did you include in that report?
I recorded my activities in the course of my police investigation, including my contemporaneous observations and summaries of my interviews with each witness.
Were you under a duty to create such a report?
Yes, this is standard procedure for police to create these reports.
Were any other matters included in your police report?
Yes, my colleague, Officer Helfrich, entered his observations into that report.
Who is Officer Helfrich?
He's another police officer who responded to the scene that night, and he assisted me in my investigation.
And without going into too much detail, what observations did Officer Helfrich enter into that report?
Objection, Your Honor. Under the grounds of 805.
I'm sorry. I heard 805. What did you say before that?
Just 805, Your Honor.
Objection 805.
So, I apologize, Your Honor. May I respond?
Yes, of course.
So as for the report itself, the report falls under 803.8, the public records exception. While I don't understand opposing counsel to have made a hearsay objection to the report itself and only hearsay within hearsay, I believe that I need to respond to the police report itself. It sets forth the police department's duties and matters observed while under a legal duty to report by an officer, namely Officer Helfrich. As to the hearsay within hearsay, I believe that opposing counsel is referring to Mr. Dornberg's statements, namely, I heard him say we should have never built the lake or the beach. My dad warned me. I should have listened to him. Within that same report, Officer Helfrich reports that Mr. Dornberg was so upset that he was moaning. He was sitting with his head in his hands. His eyes were very red and watery, and he had very red and watery. As such, I believe this also falls under the excited utterance exception if it does not fall under 801 D2D for Mr. Dornberg's agency as a person who planned this party.
Selimos, if I've already ruled that he is an agent, is that the hearsay within the hearsay your objection to under Rule 805?
No, Your Honor. If I may constructively approach if we are not already and be heard a little bit further on this issue. Thank you. So the basis of my 805 objection concerns Officer Helfrich specifically. I do not believe that 803.8 sufficiently saves the supplemental part of the report that opposing counsel is attempting to admit, because there is a second prong to the public records section, which requires that I, as the opponent of this offered evidence, do not show that the source of information or the circumstances surrounding it indicate a lack of truthfulness. Now, if we consider the fact that Officer Helfrich is not available for cross-examination, we have no idea anything about Officer Helfrich outside of what is being said by Sergeant Bell, and upon cross-examination, we will see that Sergeant Bell's truthfulness is also somewhat questionable. It leads me to believe that 805 simply just cannot be addressed without calling Officer Helfrich, which is unfortunately impossible today. Also, if I may be permitted to amend my objection, Your Honor, I have another grounds as well.
You may constructively amend.
Thank you. Under FRE 401, the relevant standard is very liberal and low. Now, I believe that this may implicate 404 instead, and so I think I would have to amend my objection to that. But essentially what I'm seeing here is opposing counsel is offering this statement by Officer Helfrich, reporting a statement by Mr. Dornberg, and for the sake of argument, we'll just suppose that he is an agent at this time. But that statement is referencing something his father told him. The facts will show that Mr. Dornberg's father was around the 1988 incident, which you have previously ruled shall be inadmissible. I believe that eliciting these statements would toe the line, if not directly contravene your previous ruling. And as a logical matter, it begs the question that something happened in 1988, making it contravene your ruling by inference.
Thank you. I will overrule the objection, as I believe both there's hearsay statements that are statements of an agent, and that the other officer, there's no indication that that declarant is unreliable. And then finally, regarding any trustworthy questions about Officer Bell, that's a cross-examination. You may proceed, Mr. Steverson.
Yes, Your Honor. Sergeant Bell, I'll ask my question again. What observations did Officer Helfrich enter into that report?
Officer Helfrich reported an interaction with Mr. Andrew Dornberg after my initial interview with him.
I'm directing you and opposing counsel to turn to Exhibit 9, located on page 53. Would you let me know when you're there?
I'm there.
And do you recognize Exhibit 9?
Yes, I do. This is the police report for that night.
Do Officer Helfrich's observations appear on Exhibit 9?
Yes, on pages 56 and 57.
At this time, plaintiff moves to admit Officer Helfrich's entry within Exhibit 9 into evidence, with the remainder of the report redacted.
Any objection?
Yes, Your Honor. I object under FRE 404.
Under 404, A or B?
Well, B, Your Honor.
B?
Yes, sir.
Response on 404B?
As we noted during pretrial rulings, Your Honor, the statement within this report simply says, we should have never built the lake or the beach. My dad warned me. I should have listened to him. There's no mention of an incident from 25 years ago. There's no mention of a prior drowning. There's no mention of a prior act. This is simply a warning. As such, 404B does not exclude this information.
I will agree and overrule the objection. Exhibit 10 is, Exhibit 9 is admitted into evidence and constructively published to the jury.
Sergeant Bell, I want to clarify one thing regarding Mr. Dornberg. Had you ever met any member of Mr. Dornberg's family before the events of this case?
Yes, I went to college with Mr. Dornberg's father.
What was your relationship with Mr. Dornberg's father like?
To be honest, it wasn't great. I didn't like him in college, and I don't care for him much now.
Why?
Well, when I was in college 30 years ago, I applied to that fraternity. Mr. Dornberg's father was the member who rejected my application. He also made me streak publicly once as well, but I joined another fraternity and moved on from that.
Does your rejection from a fraternity 30 years ago impact your ability to testify in this case?
Absolutely not. Like I said, that was decades ago, and my personal feelings regarding Mr. Dornberg's father do not change my testimony in any way.
Sergeant, let's return to the night of May 24th, 2019, and talk about the conditions you observed at the defendant's party. Besides the empty cups and bottles on the ground, what, if any, alcohol did you see at the defendant's party?
I saw beer sitting out on the tiki bar, which was sitting out next to the pool.
Were there other signs of alcohol use at the defendant's party?
All over the place, yes. Besides the smell of alcohol alone in the air, the cups and bottles on the ground, the tiki bar, Mr. Dornberg's obvious use of alcohol really indicated that there was plenty of alcohol available at this party.
How did you access the fraternity's property that night?
I just walked right up from the sidewalk onto the front lawn. There wasn't a fence or anything around their yard. It was just out in the open.
You mentioned a tiki bar earlier. Where was the tiki bar on this lawn?
It was sitting out in the open as well on the front lawn next to the house, just to walk up from the sidewalk.
Where was the pool on the lawn?
The pool as well was just sitting out in the middle of the front lawn next to the tiki bar, so I could just walk up from the sidewalk to all of those things.
No further questions at this time, Your Honor.
Thank you very much. Cross-examination?
Yes, Your Honor, that will be conducted by me. Sergeant Bell, good evening. Now, on direct examination, I heard a couple of interesting things. The first one being that you testified that you investigated the scene, correct?
That's correct.
And you first saw Kay Denning near the water?
Yes, that's right.
And she was surrounded by a small group?
Yes.
And you later learned that these were Zeta Lambda Nu brothers in this group?
Yes.
And yet you only interviewed 3 people at the scene.
I canvassed other witnesses, but no one else had any relevant information.
Now, you secured evidence on scene, correct?
That's right.
You found a marijuana pipe.
Yes.
And you found that this pipe had residue from Kay Denning on it.
Yes.
And you secured liquor bottles.
I'm sorry, could you repeat that?
Pardon me, Sergeant Bell. You secured liquor bottles.
Yes.
And you learned in your investigation that Kay Denning climbed up on that chair.
Yes.
And, Your Honor, if I may constructively approach, if I may direct opposing counsel's attention to what has been previously admitted as Exhibit 11 by the plaintiff. Sergeant Bell, you have that in front of you?
Yes.
Isn't that Kay Denning's autopsy report?
Yes, it is.
And how do you know?
Because I collected it in the course of my investigation.
Now, I would like to next hand you what shall be marked as Defense's Exhibit 12. Aren't these Kay Denning's lab report results?
Objection. While I understand this is stipulated to, I would ask that opposing counsel enter an exhibit before the witness testifies as to its contents.
Isn't this exhibit already in?
It's stipulated to, it hasn't been admitted, Your Honor.
I can admit it. At this time, the defense moves to admit Exhibit 12.
Exhibit 12 is admitted, I understood. Okay, Exhibit 12 is admitted.
Allow me to repeat my question, Sergeant Bell. These are Kay Denning's lab report results, correct?
That's correct.
Now, Exhibit 12, if you still have it in front of you, says Kay Denning's blood alcohol level was 0.19.
That's correct.
And the legal limit in Lone Star is 0.08, correct?
Yes.
So, I mean, simple math, 0.19 is about double 0.08, correct?
Yes.
So Kay's blood alcohol level was double the legal limit?
Yes, there was plenty of alcohol at that party.
Now, Sergeant Bell, let me redirect your attention back to Exhibit 11's third page, which for opposing counsel and the court is PDF page 61. Sergeant Bell, do you have this in front of you?
Yes, I do.
What does it say under cause of death?
I'm sorry, I'm not seeing that on 61.
Perhaps I have the page number wrong, so excuse me. Let me double check just in case. On page 61, I see under a bolded and underlined line that says opinion. Oh, no, I'm sorry, I just misquoted it. What would you say is under the subheading immediate cause of death?
Trauma to skull and brain.
Now, when you collected evidence, you never considered taking the lifeguard chair?
I'm sorry, can you repeat that?
You never considered taking the lifeguard chair into evidence?
No,
And you didn't even measure the height of the chair?
no,
You didn't measure the depth of the water?
no, it looked to be about 2 to 3 feet.
Now, Sergeant Bell, direct your attention once more to Exhibit 11. What does it say under manner of death?
Reported dive or fall into shallow pool.
Now, Sergeant Bell, based on your investigation, what's the only thing at the accident scene that Kay Denning could have been on top of to lead to these unfortunate circumstances?
We have established that she jumped off of the lifeguard chair.
Now I want to turn back to something else you said on direct. You said earlier that you rushed Zeta Lambda Nu fraternity, correct?
Yes.
And you got a bid, right?
For Zeta Lambda Nu,
Correct.
I joined another fraternity.
Forgive me, Sergeant Bell. It seems like you may be... You pledged Zeta Lambda Nu fraternity, correct?
That's right.
And you didn't get into Zeta Lambda Nu fraternity specifically, did you?
No,
But you have no hard feelings, right?
no,
And despite that, you recall streaking across the University of Lone Star football field?
yep,
And that was Zeta Lambda Nu's idea.
yes, it was.
So for the sake of the jury, let's back up a second. They didn't reject you in writing.
No, they did not.
They didn't tell you over the phone.
No.
They told you it was over in person.
Yes.
But it wasn't a one-on-one conversation.
No.
You were with a group of your friends.
Yes.
And Andrew Dornberg's dad told you the news.
Yes, he did.
So, I mean, let me direct your attention to this piece of paper right here for opposing counsel in the court. That's PDF page 21, and that is your deposition, Sergeant Bell.
Yes.
Now, you were under oath when you were deposed, Sergeant Bell,
Yes.
like you're under oath right now.
Yes.
Now, look at the last page for me then. Line 1. Read it silently while I read aloud. Quote, yeah, like I said, the guy's a jerk, end quote.
Objection, improper impeachment.
Hans?
Your Honor, I've already established that Sergeant Bell's testimony here today was that she has no hard feelings against Andrew Dornberg's father. And now I am presenting an inconsistent statement because if I may constructively approach and present an offer of proof, the next question that I would ask, and then Sergeant Bell's response would be that guy is in reference to Andrew Dornberg's father.
Objection is overruled. It is proper impeachment. Go ahead.
Let me repeat that for the sake of the jury, Sergeant Bell, if you're still with me. Quote, yeah, like I said, the guy's a jerk, end quote. Is that what's written on that page, exactly how it's printed?
Yes, but you asked me if I had hard feelings towards the fraternity, not his father.
That is correct, but I think my meaning is unequivocal between both sentences.
I'm sorry, I didn't understand that difference.
No worries, Sergeant.
So please just ask questions. Thank you.
Yes, sir. The guy you're talking about, the guy, is Andrew Dornberg's dad, right?
Yes.
But that was 20 plus years ago, Sergeant Bell.
Yes.
Now, Sergeant Bell, you did a deposition in this case,
Yes.
and you were under oath in that deposition,
Yes.
and you maintain that you still have no hard feelings toward Andrew Dornberg's father.
Once again, I said I have no hard feelings towards the fraternity, not his father. I did establish that I'm not a big fan of his father.
All right, I'll move on. Sergeant Bell, let's return to the parts of your investigation that you did manage to complete thoroughly. To reorient the jury, you spoke with Andrew Dornberg during your investigation that night,
Yes, I did.
and referring to Exhibit 9 that's already been admitted, he told you that Zeta Lambda Nu takes great pains to avoid serving alcohol to anyone not of age.
Yes, that's what he said.
And
Objection. This portion of the report was redacted, Your Honor.
Awesome.
Your Honor, if we've already ruled that during the party, Mr. Dornberg was an agent of the fraternity under 801 D2D, I fail to see why it would not be admissible now.
Because 801D2 is a statement of a party opponent. You're requesting hearsay.
I didn't, Your Honor, I didn't believe that that portion of the report was redacted, but perhaps I missed it. I will move on.
Okay, thank you.
Now, Sergeant Bell, in the course of your investigation, you learned that Mr. Dornberg was upstairs when Kay Denning got hurt.
Yes.
And in the course of your investigation, you learned that Mr. Dornberg didn't serve Miss Denning any alcohol.
No, it seemed as if she had refilled her own cup in the backyard.
So you admit that Kay Denning had her own cup for alcohol.
Yes.
And then you observed in the course of your investigation, Mr. Dornberg start crying and asking about Kay Denning's condition.
Yes, he was very startled by the accident.
Sergeant Bell, you also spoke with Courtney Perez that evening.
Yes.
You learned that in the course of your investigation, Kay Denning climbed the lifeguard chair alone.
Objection. Hearsay. Or knowledge based on hearsay, excuse me.
I'm sorry, what, Mr. Stevenson? I heard hearsay, but
Knowledge based on hearsay. As to...
foundation?
Yes, Your Honor.
Okay. The objection is foundation. Response?
Or I apologize, Your Honor. I think that knowledge based on hearsay as to the detective's or sergeant's conversations with Courtney Perez.
Okay, I think foundation, you're challenging the foundation of the knowledge of the witness then. Ms.
Your Honor,
Selimos?
may I have permission to confer with co-counsel? Briefly.
Yes.
Thank you.
All they have to do is get close to each other without masks so they can confer.
I'm sure there's plexiglass there, just like the VP debate tomorrow night.
Absolutely. Can I ask a question while they're conferring? I realize this
Yes,
is not
sure.
appropriate trial behavior, but I noticed at least once in the materials, it suggested that Mr. Dornberg was the president of the fraternity. Do we all agree he was the treasurer? Are we accepting that, not the
That's my
president?
understanding as a treasurer.
I can
Okay.
clarify that point, Your Honor. He's currently the president, is my understanding. He was the treasurer during the events at issue.
So after this, he was elected by his brothers to be the president. Nice return.
Yes, Your Honor.
I noticed that in the materials and I was confused. So yeah. Okay, thank you.
I have returned.
Okay, go ahead, counsel. So there's a pending objection based on foundation.
Foundation. Well, I can just lay more foundation, Your Honor.
That would be the good remedy. Go ahead. See if you can lay foundation.
Thank you. Sergeant Bell, you said on direct that you interviewed several people that night at the scene of the accident, correct?
3 people in particular, yes.
And one of those people that you personally interviewed is Mr. Courtney Perez, correct?
That's correct.
And this interview was a part of the legal duty that you have to report as a police officer conducting an investigation, correct?
That's correct.
And you work for the University of Lone Star Police Department, correct?
Yes.
Now, let's turn to what you said, let's turn to what you learned in the course of your investigation when you spoke with Courtney Perez that evening. You learned that Kay Denning climbed the lifeguard chair alone, correct?
Objection. Knowledge based on hearsay.
So again, I would understand, I'm interpreting that as an objection to foundation. You're asking her things outside of her personal knowledge. So I will sustain the objection.
Okay. I'm just going to, no further questions, Your Honor.
Okay, thank you. Any redirect, Mr. Stevenson?
Yes, Your Honor, briefly. Let me write down the time really quickly. Sergeant Bell, you were asked about your relationship with Mr. Dornberg's father and the fraternity a little bit on cross-examination. Did Mr. Dornberg's rejecting you from the fraternity 30 years ago impact the course of your investigation?
Not at all. Like I said, that was 30 years ago.
Does it impact your testimony today?
Not at all.
Does it impact any interaction that you have with the fraternity?
Not at all.
No further questions, Your Honor. May this witness be excused?
Yes, Sergeant Bell, you're excused. Thank you for your testimony tonight. Does the plaintiff rest?
Yes, Your Honor, the plaintiff rests.
Plaintiff rests, all right. We will, before we take a short break, we will entertain any motion for directed verdict, and I'd ask counsel to keep their comments as succinct as possible. Is there a motion from the defense?
Yes, Your Honor, briefly. Your Honor, even if you take the facts in the light most favorable to the plaintiff, they've still just haven't shown any causation. What you've heard is that Kay Ditting was alone when she climbed up to the top of the chair and she made the decision to jump into a shallow pool of 3-foot water. She did this while she was intoxicated. They haven't laid any sort of evidence that shows she was influenced in that decision, and therefore you should dismiss the case or rule for the defense, Your Honor.
A directed verdict. Response from the plaintiff.
Your Honor, viewing the evidence in the light most favorable to the plaintiff, a reasonable jury could find that the defendant was negligent and that the defendant's negligence proximately caused Kay Denning's death. A reasonable jury could find that the defendant's actions and omissions demonstrate that their failure to use ordinary care, that they failed to use ordinary care and were therefore negligent. And a reasonable jury could also find that, but for Andrew Dornberg's invitation to Kay Denning, she would not have been on their property that night, that but for the defendant's beach party props, she would not have sustained fatal injuries, and that a person using ordinary care would have foreseen that Ms. Denning's accident or a similar one might occur. A reasonable jury could therefore find that the defendant's negligence proximately caused Kay Denning's death, and the plaintiff respectfully requests that the court deny the defense motion.
I'm going to grant the motion so we can all head home early. Take it up with Justice Hart. No, I believe that there is enough sufficient questions of fact to be submitted to the jury. So at this time, we will take a brief recess. I have 7:04, and we will reconvene precisely at 7:10. So 6 minutes, and feel free to mute your microphone and turn off your camera or leave them on. But please don't join the Zoom. Do not leave the Zoom so that we can all reconvene in 6 minutes. Thank you.
Thank you.
Your Honor, would you like an update on time before we move forward?
That'd be great. Thank you.
Right now I have the plaintiff's case at 22 minutes and 3 seconds. And the defense's case at 22 minutes and 46 seconds.
Close. Okay.
Yeah.
Thank you. And I have 7:10. And there's Justice Hart. All right. I believe in running a timely courtroom, so we will reconvene in the matter of Denning versus Zeta Lambda Nu Fraternity, and we are ready for the defendant's case.
Thank you, Your Honor. Sorry, we were trying to avoid that. Thank you, Your Honor. At this time, the defense calls witness Andrew Dornberg.
Andrew Dornberg. Sir, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your name for the record.
My name is Andrew Dornberg.
Thank you. You may commence questioning.
Mr. Dornberg, let's both take a deep breath and introduce you to the jury. Who are you?
Again, my name is Andrew Dornberg.
And how old are you?
I am 22 years old.
Do you have a job?
I do. I work part-time as a lifeguard for the athletic center.
Are you a student?
I am. I'm a full-time student at the University of Lone Star.
How else do you spend your time at the University of Lone Star?
Well, outside of my duties as a lifeguard and my responsibilities as a full-time student, I am the active president of the Zeta Lambda Nu Fraternity here on campus.
When did you become the president?
Just this year.
And were you the president last year?
I was not. Last year I was the treasurer.
Briefly, tell the jury what kind of stuff a treasurer does for a fraternity.
Well, they are primarily responsible for overseeing the budget. This includes, accounting for any money that comes in the form of member dues or fundraising, as well as accounting for any expenditures made on behalf of the fraternity.
Tell the jury why you're here in court today.
Well, I was one of the last people to see Kay Denning before her tragic accident.
We will get more into that, but let's first back up and explain how you met Kay Denning. Please tell the jury when you met Kay Denning.
Well, I had first met Miss Denning early on the evening of May 24th, 2019, and I will never forget this day because it was a horrible day for me.
Where were you two?
Well, outside of the Zeta Lambda Nu Fraternity House, in the front yard, or I was positioned in the front yard and she was adjacent to, and I was sitting atop a lifeguard chair.
Why was there a lifeguard chair?
Well, we were throwing a beach-themed party of sorts. We were to have food and drinks, movies playing on a projector that we had, as well as music. And there were lots of props and decorations, and this chair happened to be one of those props.
Your Honor, permission to constructively approach the witness.
You may approach.
Mr. Dornberg, I'd like to hand you what's been previously admitted as Plaintiff's Exhibit 5. Do you have that in front of you? For opposing counsel in the court, it's on PDF page 49.
I do.
Is that the chair you're talking about?
That is the chair.
Please explain. Your Honor, permission to publish constructively?
Exhibit 5 has already been published to the jury as it's been admitted. Thank you.
Thank you. Mr. Dornberg, please explain the rest of the party scenery to our jury.
Well, as I said, it was a beach-themed party. So we had constructed a pool using tarps to contain the water within the pool and sandbags to surround the perimeter of the pool. We had also strewn out sand all along the front yard to add to the beach theme of sorts. There was a tiki bar also within the front yard adjacent to the pool, which was where some rum drinks were being served. And then the lifeguard chair that was previously mentioned was positioned within the pool.
So it sounds like that was a constructive swimming pool.
Correct.
All right, thank you.
with the scene set, Mr. Dornberg, what happened next?
Well, as I was sitting atop my lifeguard chair, I happened to see Miss Denning walking past with somebody who I now know to be Chris Bloom. I know that she was in a pink shirt. I distinctively remember her being very beautiful, and I wanted to talk with her. So, you know, I casually asked if she was coming to the party that night.
And when you met Miss Denning, were you standing on this lifeguard chair?
No, I was sitting on the lifeguard chair.
Well, why were you sitting?
Because it's a chair, and that's what chairs are for.
Let's stop and focus on the party. Did you see Miss Denning during the party?
I did not.
Why not?
Well, as far as I know, I didn't get.
I'm sorry, I missed that.
She didn't get in.
And why?
It was my understanding that she had left her ID at home.
What kind of impression did that give you?
That she was 21, and if she had had her ID, she would have been able to get into the party.
So did Miss Denning make it to the party at all?
No, the party had already ended before I saw her again that night.
Were underage guests allowed at the party?
No, they were not.
Let's talk about after the party had ended. You said you saw Miss Denning again. When was that?
Around 1:30 or so in the morning.
And what time was the party officially over?
At or before 1 a.m.
Are parties allowed to go past 1 a.m.?
No, it's actually school policy that the parties must be over by 1 a.m. But we did have plans to leave to go to a party just down the street.
So what happened next?
Well, I went upstairs to change into a shirt and get freshened up.
Let's briefly change gears and talk about alcohol. Did you serve Miss Denning alcohol?
No, absolutely not.
Why?
There was never a chance. The party had already ended by the time she showed up.
By the time she showed up, was Miss Denning holding anything?
I believe she had a cup of red liquid that was about half full.
How do you know that?
I saw it.
Was Zeta Lambda Nu serving red liquor that evening?
No, we only had rum and beer, which are yellowish brown in color.
Finally, I would like to talk about why Miss Denning is not here with us today. Tell the jury what happened while you were upstairs.
While I was upstairs changing my shirt, I remember hearing a scream, and it wasn't the sort of scream that you hear when somebody is having fun or playing or anything like that. It was the sort of scream that you hear when somebody needs help. And after hearing this blood-curdling scream, I ran down the stairs as fast as I could and went towards the front yard where I thought the scream had come from. When I reached the front yard, I saw Miss Denning face down in the water, and by then it was too late. It was a horrible, horrible sight, and it will be burned into my mind for as long as I live.
Nothing further, Your Honor. I tender this witness for cross-examination.
Thank you, sir. Cross-examination. Mr. Smith?
Yes, Your Honor. Mr. Dornberg, I want to talk about that beach party. You helped organize the fraternity's party on May 24th, 2019, right?
I'm sorry, there was a cutout at one point. Can you repeat the question?
You helped organize the fraternity's party on May 24th, 2019, right?
I did have a say in proposing a theme, correct?
The party had a beach theme.
Yes.
The fraternity showed old movies on a big screen during the party.
Yes.
The fraternity made sure there was plenty of alcohol.
There was alcohol, both rum and beer being served at the party.
But the fraternity made sure there was plenty of alcohol, right?
Yes.
You coordinated setting up a makeshift pool.
Yes,
The pool was placed out on the house's front lawn.
that is correct.
You placed a lifeguard chair in the water.
Yes.
want to talk about that lifeguard chair. You work as a lifeguard at a local athletic center, right?
Yes, I do.
You took the lifeguard chair from your employer.
That is correct.
You found it out back behind the athletic center.
Yes.
You can't tell us whether you had permission to take that chair.
I don't remember explicitly receiving permission, no, but it was out of commission at the time.
You described that chair as rickety.
Yes.
You can't tell us whether your employer considered that chair safe to use.
I cannot.
We'll talk about the presence of alcohol that night. You set up a tiki bar, right?
Yes, we did.
The tiki bar was on the front yard.
Yes, it was.
You didn't arrange for somebody to staff the tiki bar.
No, because we had already had steps in place to make sure people were 21.
You bought a few kegs for the party.
Yes, we did.
The kegs were out in the backyard.
That is correct.
You didn't have somebody watching those kegs.
Not specifically instructed to do so, no.
In your words, you made sure there was plenty of booze at the party, right?
Yes.
You didn't arrange for anybody to make sure people weren't drinking too much during the party.
We did not.
We'll talk about your first meeting with Kay Denning. You met Kay Denning as she was walking by the house.
That is correct.
As she was walking by, you were sitting on a lifeguard chair.
Yes, I was.
You asked if she was coming to the party.
Yes, I did.
You then went down to the side of the pool to talk to Kay Denning.
Yes.
As you climbed down from the lifeguard chair, you nearly slipped.
Yeah, I remember almost slipping, but the water made it a pretty slippery place to be.
You asked Miss Denning for her phone number.
Yes, I did.
You obtained both Kay Denning's number and Chris Bloom's number.
Yes.
You never asked Miss Denning how old she was.
I did not. I assumed that if she were to be coming to the party, it was conditioned upon her being of age.
We'll talk about how you kept in contact with Miss Denning that night. You communicated with Miss Denning via text messages, right?
Yes.
Directing opposing counsel and the witness to page 51, Exhibit 7. Mr. Bloom, or excuse me, Mr. Dornberg, please let me know when you're on that page.
I'm there.
Exhibit 7 is a copy of a conversation you had with Miss Denning on that night, right?
I don't know if I would deem it a conversation, but there was some back and forth messages, yes.
This is a fair and accurate copy of that dialogue, right?
I don't recall them prior to seeing this, but there is some familiarity, yes.
Your Honor, the defense, or excuse me, the plaintiff moves to admit Exhibit 7, subject to redaction, with Kay Denning's responses and text messages redacted.
So the proposal is to admit a redacted version of Exhibit 7, redacting the messages from the decedent. Is that right?
Yes, Your Honor.
Response?
Your Honor, I object under hearsay 8011, and since apparently it is not implied, I need to also object under 805. What I see in front of me are 3 declarants, and I have heard foundation to admit the hearsay of 1, but I have not heard anything for the other 2. And I find that a redaction of half of a dialogue between only 2 people is insufficient context. So if we're going to go with admitting this, I would compel Ms. Denning's statements to be included, but that's not what I would like to do, Your Honor. I would like to have this exhibit excluded because the first declarant is Andrew Dornberg. We could argue that Mr. Dornberg is acting as an agent of the fraternity when he invited Kay Denning, but I'm looking at one specific text message in this chat log where there's no way that he's acting within the scope of his duties. And if you would like me to constructively approach, I could highlight that message for you, Your Honor.
Tell me
Secondly,
the timestamp on that message.
yes, Your Honor, that would be the timestamp of 6:44 p.m. May 24th of 2019.
Haha, you seem to be an excellent swimmer.
Yes, Your Honor, that one. And
Okay.
my view is that a flirtatious text message sent to a complete stranger that has no reference to the fraternity that bestows any agency upon Mr. Dornberg is certainly not within the scope of 801 D2D. And as I said before, any plain meaning interpretation of the treasurer of a fraternity does not include explicitly personal romantic interests and sexual attraction. I think that redaction is trying to shove a square peg in a circular hole, Your Honor. Also, we've heard no foundation, and there can be no hearsay exception for the phone company that transcribed these text messages and created a report. I've heard nothing on that because there is nothing on that.
Response, Mr. Smith?
Your Honor, if the defense would prefer to admit the document in its entirety, the plaintiff is fine with that.
All right. Well, I will overrule the objection. The particular line item may have been of personal nature, but the overall conversation is in the context of an invitation to a party by an officer of the fraternity. So it is a statement of a party opponent under 801 D2. Further, these are prior statements by the witness, and in light of the defendant's request that the exhibit be admitted unredacted, I will admit Exhibit 7 and it is constructively published to the jury.
Mr. Dornberg, at 6:37, you sent a text message saying, "Hey, it's Andrew, can't wait to see you at the party tonight," right?
I did.
7 minutes later, you sent a text saying, "You can dive into my pool anytime."
Again, I had led with haha and ended with a winky face. I assumed that any reasonable person would take that to be a joke.
The text message, though, said, "You can dive into my pool anytime."
Winky face, yes.
You sent 8 more text messages to Kay Denning that night.
Let me count. Give me one moment. That appears to be the case, yes.
All of those text messages related to inviting Kay to the party or inquiring about her whereabouts, right?
Yes.
We'll talk about what happened later that night. Kay Denning did come to the party later that evening, right?
Kay Denning actually came after the party had already ended, but she did come to visit a new fraternity house.
When she arrived, there were still movies playing in the backyard.
That is correct.
But when she showed up, you believed she'd been drinking.
Yes.
When she first showed up, you didn't tell her to leave immediately.
I did not, but we, again, had made plans to leave for another party shortly after I had changed my shirt.
You said that the two of you could find a different party.
Yes.
So after you made plans to leave with her, you went up to your room to change your shirt.
That is correct.
You told her you would meet her in the front yard.
Yes, I did.
When you went up to change your shirt, you left her unattended in the backyard.
Yes, I did.
When you came down to the front yard after changing your shirt, she was laying injured in the pool.
Yes.
No further questions.
Thank you. Selimos, redirect.
Mr. Dornberg, when you first spoke to Kay Denning, you just said on cross-examination that you were sitting on that chair.
That is correct.
And did you slip?
I did not. I almost slipped.
But you were fine.
Oh, yeah. More than okay.
Did I hear an objection, Your Honor? I just wanted to double check.
I'm sorry, couldn't hear you. What?
I thought I heard an objection. It might have been a
objection to
Your
leading.
objection, Mr. Smith?
Allow me to rephrase, Your Honor, for the sake of brevity. Mr. Dornberg, What did you almost slip into?
I slipped into the pool.
Why was the chair in the water?
Well, we had deemed it a precautionary measure. Risk management is important in fraternities, so we figured if somebody had slipped off the chair from a seated position, that they would be okay falling into the water.
Mr. Dornberg, I have one final question, STEM, and it goes like this. Earlier, we saw some text messages published to the jury. Mr. Dornberg, you said, what do you do for work?
I'm a lifeguard.
So, Mr. Dornberg, how many pools do you have control over?
The only pool that I have control over is the pool that I lifeguard for.
No further questions.
Thank you very much, Mr. Dornberg. You are released as a witness, and we'll hear the defendant's next witness, please.
At this time, Your Honor, the defense calls Courtney Perez.
Mr. Perez, will you please raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Please state your full name for the record.
My name is Courtney Perez.
Thank you. You may proceed, Mr. Smithers. Yes, okay. Trying to see what box you're in.
Mr. Perez, are you a student?
Yes, I'm now a senior at the University of Lone Star.
Do you work on the side?
Yeah, I manage a small business on campus.
What is that small business?
I help student organizations plan their social events.
What types of social events do you typically help plan?
I would say most of my time is spent helping fraternities plan their party.
Mr. Perez, why are you here in court today?
I'm here because I was hired by the Zeta Lambda Nu fraternity to help plan a party on May 24th.
What type of party was this?
Well, I was involved in the planning of it, and the theme that was decided upon was, you know, a teen beach movie. So it was intended to give that vibe of like a 80s movie vibe, you know, and they were very imaginative and creative with it.
Now, you said they hired you to help with this party. What were you actually supposed to be doing?
So my duties included helping with the setup of the party. I contracted with vendors to help provide food for the party, and I worked security, and I also helped with the cleanup afterwards.
Let's talk about the setup a little bit. How was this party decorated?
Yeah, you know, like I said, it was very creative. They had brought in a bunch of sand into their front yard to help create a little mini beach. They built a little pond out of a tarp and lagoon, which they filled up with water. They brought in a tiki bar to set up in the back, and they also brought in a lifeguard chair.
Do you know who was invited to this party?
Yes, in order to be a guest at this party, you had to have received both an invite from the fraternity and you needed to be over 21.
Objection. Hearsay.
Response?
Your Honor, I don't believe that this is hearsay. I've laid the foundation that he was involved with the planning of this party, and he could testify to what he knows and what the nature of that party was.
Agree that the question did not seem to call for hearsay, so the objection is overruled.
Mr. Perez, I'm going to ask again, who was invited to this party?
Yes, you had to be over 21 to be a guest at the party.
How was this age rule enforced?
I stayed at the entrance of the fraternity all night, and I checked the ID of everyone who came as a guest.
Were there any other measures taken?
Yes, we had constructed a sign to place over the fraternity door so that anyone coming up would see it.
Who made the sign?
Andrew and I did.
Would you recognize it if I were to show it to you?
I would.
Your Honor, may I direct the court as well as opposing counsel to page 47 of the PDF file.
Exhibit 3.
Yes, correct.
Okay, Exhibit 3.
And may I constructively approach the witness with the same?
You may.
Mr. Perez, do you have Exhibit 3 in front of you?
I do.
Do you recognize it?
Yes, it's the sign we made.
Is it fair and accurate?
Yes, I believe so.
At this time, Your Honor, the defense moves to enter Exhibit 3 into evidence.
Any objection?
I believe that this was the exhibit that was subject to my motion to eliminate. May I renew my objection at this point, Your Honor?
Objection. Let's remind us of the basis for the record.
Hearsay.
Hearsay. And who do you contend is the declarant?
Apparently, Mr. Dornberg at this point, if he made the sign, as I believe what the testimony I heard. Is it, or it may have been Mr. Dornberg and Ms. Perez. Is that correct?
By the nodding testimony, Mr. Smithers, I believe that's correct. I do not believe this qualifies as an out-of-state statement under 801. Therefore, the objection is overruled.
Permission to constructively publish to the jury?
The Exhibit 3 is admitted and constructively published to the jury.
Mr. Perez, where was this sign?
As I said, it was posted above the entrance to the fraternity so that anyone who came to the party would see it.
How big was it?
It was about 5 to 6 feet long. It was pretty big.
Now let's talk about the party itself. When did it start?
You know, sometimes these parties have such soft starts, but I believe it was around 8 p.m.
What were you doing during the time of the party?
Once the party had begun, my job was to check IDs at the door.
Were you there the whole time?
Yes, I was. It was my job.
Did you ever see Miss Denning while you were checking IDs?
I did. She came, I think, a few hours after the party had started.
What happened?
Well, I asked for her ID. She told me that she had left it back at her apartment, and I told her if she couldn't produce a valid ID, I couldn't let her in.
Did you let her in?
No, absolutely not.
So what happened after that?
Well, she left with her friend, and I went back to my job.
When did the party end?
Party ended strictly at 1. Campus has a pretty hard rule about making sure all fraternity parties over at 1, and I take that restriction very seriously.
So what were you doing after the party had ended at 1 o'clock?
Well, once the party had ended and all the guests had left, I began cleanup.
Did you see Miss Denning at all when you were cleaning?
Yes. When I went to the back of the fraternity house, I did see her in the backyard with Andrew.
About what time was it that you saw her?
It was well past 1.
What did you do when you saw Miss Denning and Andrew in the backyard?
I told them, hey, party's been long over. You're not allowed to be here anymore. I need you to leave.
So what did you do next?
I left her with Andrew and I went back to my duties inside.
Mr. Perez, did you ever see Miss Denning again that night?
I did.
Where did you see her?
While I was inside cleaning, I could see through the front window that Miss Denning was now in the front yard.
What was she doing?
She was wading around in the pond. At first, I thought maybe she was just messing around in there, and I got a little annoyed, but then I noticed she started approaching the lifeguard chair.
So what did you do?
I yelled at her, you know, what are you doing? I asked you to leave. You need to leave.
How did she respond?
Either she ignored me or she didn't hear me because she kept moving towards the chair. She started climbing it, and then at this point, I started to get more upset. If I remember, she was laughing and had this big cup in her hand.
Why did you take notice of the cup?
It was really unusual. It had a big gulp written on it like you would get at a convenience store. Like, it was not any cup that I had seen at Zeta.
What did Miss Denning do when she climbed the chair?
She started climbing. She was slipping a little bit, and when she got to the top, she stood up, and that's when I was like, you really need to get down. You're gonna hurt yourself. But she couldn't hear me, and she dove in.
Mr. Perez, let's backtrack a little bit. One of your responsibilities that you said you had with this party was to supervise the setup. Were there any problems that you had during the setup?
Oh yeah, I brought it up at our planning meeting that, I was really worried about the chair for liability reasons. It looked a little old and rickety to me. What I was really worried about, was at a party, everyone's going to want to sit in this thing, but if it's in the sand and it's in this condition, chances are someone's going to topple over and fall over onto the sand.
So why were you worried about the chair in the sand?
Well, just because, with that chair and on the sand, it's just not going to be very stable to sit in. And then especially if, someone starts fighting with the opportunity to get to sit in it, that could also just be a recipe for people falling over.
So what happened after you had these concerns?
If I remember correctly, I brought it up to Andrew and the rest of the planning group, and it was decided that to avoid this issue, the chair would be moved into the water and weighed down with sandbags on every leg. That way it would be impossible to take the chair over. And if you were to slip either sitting or on the steps, you would just fall back into the water. That would cushion your fall, and hopefully you'd walk away with no injuries.
Mr. Perez, how deep was the water?
It was, I want to say 3 feet. It was about somewhere between my knee and my hip. So, it was deep enough that it would actually provide you some cushion, but also you could still put your feet on the ground.
Now let's go back to Miss Denning. Did you see Miss Denning fall off of the chair?
No, I didn't. I can't describe it any other way than saying like she dove off of it.
What do you mean when you say she dove off the chair?
I mean, if she got to the top, she stood up, put her hands over her head like this, and then like gave a little hop like she's coming off of a diving board.
Your Honor, I have no further questions from Mr. Perez at this time, and I tender him for cross-examination.
Thank you, Mrs. Smithers. Mr. Steverson.
Yes, Your Honor. Good evening, Mr. Perez. I'd like to start by learning a bit about you and your working relationship with the defendant fraternity. You performed party planning services for the defendant's May 24th party.
I did.
The defendant's is one of your best customers.
Yes, we work together frequently.
The defendant has a party planning committee.
Yeah, people involved in planning parties, yeah.
So yes.
Yes.
And you attended a meeting with the defendant's committee.
Yes, I did.
And Mr. Dornberg was the head organizer for the party.
Head organizer in the sense that he was really the creative force behind it.
So yes, he was the head organizer for the party.
Well, I take objection with your characterization because while he's involved with, ideas about themes and whatnot, we're all taking a pretty significant part in how this party comes together.
So is it your testimony that Mr. Dornberg was not the head organizer?
In the sense, if I'm understanding you correctly, that you're asking if he said, I'm in charge of this, this, and this, and this, because honestly, many of my duties were more relevant in terms of putting together the party.
So, Mr. Perez, I'm asking you very clearly. Is it your testimony that Mr. Dornberg was not the head organizer?
Could you clarify what you mean by head organizer?
I mean that he was the head organizer of the party, correct?
It was his idea to have the party, correct?
And he was also the head organizer.
He helped put it together, yes.
Yeah. He suggested how the fraternity should build a pool.
Yes, that was part of his Team Beach theme idea.
And he was adamant that they host a beach themed party.
Yes.
And how to build the pool, Mr. Dornberg provided all the plans for how to do that.
Yes, he helped construct it.
Yeah, he was in charge of that, yes.
He was, again, the lead creating force. It's sort of hard to characterize this as in charge, you know?
Okay, so Mr. Dornberg was the lead creative force for the party.
Yes.
Well, since we've talked about your ongoing business relationship with the defendant fraternity, let's discuss the concerns you had while planning the party. You thought building the pool sounded like a bad idea.
Mm-hmm.
Is that a yes?
Yes. It was part of my concerns with the party, yes.
So yes, you thought building the pool sounded like a bad idea.
Yeah, I mean, who wants to get wet at a party?
You thought it was a bad idea for safety reasons.
I was worried about liability, yes.
You were concerned especially about the lifeguard chair.
Yes, I was worried it could topple over.
And you thought the lifeguard chair was also old and rickety.
Yes, and that's why I was worried it would topple over.
So yes.
Yes to your characterization.
You weren't sure that the chair would stay put on the sand.
That's correct.
You weren't sure it would stay put because you figured people would be climbing on it during the party.
I figured that if someone were to try to sit in it between the chair and the sand, it could topple over, yes.
So you weren't sure it would stay put because you figured people would climb on it during the party.
Who doesn't want to sit in a chair when they see a chair?
Is that a yes?
Yes.
Okay. Well, we're recording the events of today, and I just need a clean answer for the record. So I'm going to ask one more time. You weren't sure the chair would stay put because you figured people would climb on it during the party.
Climb and sit, yes.
So yes.
Yes.
You discussed your concerns with Mr. Dornberg before the party.
I did.
And in response to your concerns, Mr. Dornberg told you that if the fraternity had to worry about every little danger in our setup, we could never have a party.
Yes, but this was after I felt satisfied by the measures he took to stabilize the chair.
So in response to your concerns, Mr. Dornberg told you that if the fraternity had to worry about every little danger in our setup, we could never have a party.
Yes, but that was not his only response to my concerns.
He also told you not to worry about it, correct?
It was part of the same sentence after it was taken care of. That is correct.
He also told you what could go wrong.
Yes, but I don't think he meant it literally.
But he did tell you that.
Yes, it is correct. He said that to me.
Mr. Dornberg suggested putting the chair in the water in case someone fell off.
While weighed down with sandbags, yes.
And that way, if someone fell off, they would fall into the water.
Yeah, so if they were to slip while on the steps or if they were sitting down and came down a little fast, they would fall into the water.
And the pool is only about 3 feet deep.
Yes.
The fraternity didn't tape off the lifeguard stand to keep people off of it.
No, they did not.
The fraternity didn't put a sign on the stand to keep people off of it.
No, they did not.
The fraternity didn't put a physical barrier around the stand to keep people off of it.
No, they did not.
The fraternity didn't take any actions to keep people off the stand.
No, they did not.
Well, let's move on from the discussions you had about your concerns over the pool and discuss your work the night of the party itself. It was your job to check IDs at the front door.
That is correct.
The fraternity had a back door.
They had a backyard and a back door, yes.
So yes, the fraternity had a back door.
Yes.
And you didn't have anybody checking IDs at the back door.
I don't see why that would be necessary.
You don't see why it would be necessary to have somebody checking IDs at the fraternity's other entrance?
The only way to enter the party would be through the front door and through me.
Okay, well, there's no fence around the fraternity.
Yes, but the party is occurring at the front of the
Objection,
fraternity.
Your Honor, lack of foundation.
Hans?
Your Honor, I'm asking the witness about his own personal knowledge about whether there's a fence at the fraternity. I don't think that there's a foundation problem with that. He's standing at the fraternity all night long. You should know if there's a fence.
In response to that?
Your Honor, I just don't believe that they've laid any foundation as to like where the actual fraternity house is located within the scope of campus and whether there would be any fences around at all. I just don't think there's been any foundation laid as far as the geography of the area.
Understood, but Mr. Perez has testified that he's present at the party and plans parties for this fraternity, so I believe it's within his personal knowledge, so the objection is overruled.
Yes, Your Honor.
Mr. Perez, I'll ask my question again. There's no fence around the fraternity.
That is correct.
And you didn't think it was important to have anybody at the back door checking IDs?
Well, I don't see how they would have been able to access the party from the back.
So no, you didn't think that that was important.
No, and I gave you my reason for why.
Okay. You didn't hang a sign above the fraternity's back door.
No, again, I don't see why this is relevant.
Because there was no fence around the back door or around the backyard.
No.
Miss Denning didn't come into the party through the front door.
Can you repeat your question? I just couldn't hear it.
No, it's fine. Miss Denning didn't come into the party through the front door.
No, she was turned away and she left the property.
But you saw her later anyways.
Yes.
And you never saw Miss Denning come in through the front door.
Well, because at that point, if you remember, I testified that I had gone back inside to begin cleaning because the party was over and it was understood that no one was supposed to be there. So because I was inside, I could not stop Miss Denning from coming from the front to the back.
But I'm sorry if my question's confusing. Let me clarify. You never saw Miss Denning come in the front door, correct?
Of the fraternity? No.
At the party, there were 2 kegs sitting out on the back lawn.
Yes, that was part of the party setup.
Those kegs weren't staffed.
No.
At the party, there was a tiki bar sitting out on the front lawn.
That is correct.
That tiki bar wasn't staffed.
That is correct. Well, staffed in the sense that there would be fraternity brothers helping, but if you're asking if there was professional staffing, then no.
So there was nobody standing checking IDs at the tiki bar.
No, because I would check the IDs before anyone was allowed in.
And again, this tiki bar is on the front lawn, which isn't surrounded by a fence.
That is correct.
You claimed the party had ended at 1.
That is correct.
No one emptied the homemade pool at 1.
That was not the first task done, no.
No. So no.
No.
No one took the lifeguard stand down at 1.
No.
Nobody put the tiki bar or the kegs away at 1.
No, I began my cleanup inside before going to the outside.
So no.
No.
Well, since we've talked about your work at the front door, let's talk about what happened to Miss Denning when you saw her later at the defendant's fraternity. You saw Miss Denning in the fraternity's yard later that night.
Could you be more specific? Because I saw her in both yards that night.
Sure. You saw Miss Denning in the fraternity's backyard that night, correct?
That is correct.
And when you saw her, she was with Andrew Dornberg.
That is correct.
The same Andrew Dornberg who helped plan the party.
Yes.
The same Andrew Dornberg who's one of the defendant's treasurers.
Yes.
At that time, you were still working for the fraternity.
Yes, I was in my cleanup duties.
And you told Mr. Dornberg that the party was over and he needed to get Miss Denning out of there.
I told both of them that it was time to leave.
Okay, but you didn't actually wait to see if they left.
It's been my experience that when I ask a person to leave property they're not supposed to be on, they comply.
And you didn't wait to see if Mr. Dornberg made her leave.
That is correct.
And Mr. Dornberg lived at the house.
I believe so, yes.
You just went back in the house.
Mm-hmm. Yes.
And a while later, you went out to take down your sign.
Yes.
You saw Miss Denning at that point in the fraternity's pool.
Yes.
You saw Miss Denning start to climb the lifeguard chair.
Yes.
You saw Miss Denning go headfirst into the pool.
I saw her stand up and dive in, yes.
Okay. You jumped into the pool to drag her out.
That is correct.
And you noticed Mr. Dornberg was there helping you drag her out.
Yes, I think he had run out behind me.
And Mr. Dornberg was clearly upset.
Yeah, as was I. We just saw someone dive head first.
And in your words, Mr. Dornberg was freaking out.
Yes, as was I.
While Mr. Dornberg was freaking out, he kept repeating, I didn't think she would really do it.
Objection,
Yes,
Your Honor.
that-
Hearsay.
What's the objection?
Hearsay, Your Honor.
Response?
801 D2D and 8032 excited utterance, Your Honor. I believe Mr. Dornberg is acting in the scope of his agency. We've heard plenty of testimony about how he was the organizer for this party. And this is he's helping pull somebody out of a pool at the party. Moreover, we've heard testimony that he was clearly upset. This is something he's saying while he's upset.
Objections overruled. Go ahead, Ms. Steverson.
Mr. Perez, I'll ask again. While Mr. Dornberg was freaking out, he kept repeating, I didn't think she would really do it.
Yes, he said that.
After you dragged Miss Denning out of the pool, someone called 911.
Yes, it was Andrew.
And while you're waiting for the ambulance, Miss Denning was lying on the sand soaking wet.
Yes.
You don't remember any of the fraternity members providing first aid to Miss Denning?
Well, I don't know if any of the fraternity brothers knew first aid, and it can be dangerous to try and apply aid when you don't know what you're doing.
You're aware Mr. Dornberg is a lifeguard, yes?
Yes.
And you don't remember anybody providing first aid?
Are you asking if I remember whether or not Andrew provided first aid?
Anybody at all?
No, no one at the scene until paramedics arrived.
You don't remember anybody putting a towel or a jacket over her body?
No.
You all just sat there waiting?
For the police and the paramedics, yes.
So yes.
Yes, I said yes.
Thank you, Mr. Perez. No further questions.
Thank you, Mr. Jefferson. Any redirect, Mr. Smithers?
Yes, Your Honor. Mr. Perez, Mr. Steverson asked you a lot of questions about the setup of this party. Now, I just want to clear up a few things. When did you have concerns about the lifeguard chair?
I had concerns when it was originally brought to the party. That's when.
Where was it when it was brought to the party?
It was placed on the sand.
Were your concerns addressed?
Yes, like I testified, I was worried about it falling over when in such an unstable position on the sand. So when it was placed in the water with sandbags, I was assured that anyone who wanted to sit in the chair would not have any trouble.
Did you see Miss Denning sit in the chair?
No, I saw her stand on it.
What did she do when she was standing on it?
She put her hands over her head and she hopped in like she was diving into a pool.
Was there anyone else in the pool at that time?
No.
Thank you, Mr. Perez. I have nothing further from this witness.
Thank you, Mr. President. You may be excused. Thank you for your testimony this evening. And with that, does the defense rest?
Yes, Your Honor, the defense rests. We would just like to renew our earlier directed verdict motion as a judgment as a matter of law. We find that there still has not been sufficient causation.
Thank you. The court will deny that motion so that the court can consider the closing arguments of the party. I'd like to proceed straight to closing. Are counsel okay with that?
Yes, Your Honor. May I have 1 minute to organize my exhibits?
Yes.
Then yes.
1 minute for the night court of Dallas County. Should I do a magic trick like Harry and I have the hat? Like, showing our age now. He just died. Didn't he just die like within the last year? That actor, night court, who was the judge. I think he just passed away.
I think you're right that he did, Michael. Very sad.
Yeah.
That is a show that makes us look so old. None of the law students will know what that show is. All right, so Emily is telling us that when it's time for us to walk away and judge, we need to move out into the other room.
Understood. Yep. So
But we'll
we'll
let
have
them do
closing
closing
argument.
first.
The plaintiff is ready to proceed whenever you're ready, Your Honor.
Okay. Is defense ready to proceed closing argument?
Yes, Your Honor, the defense is ready to proceed.
Okay, Mr. Steverson, are you making closing argument?
Yes, Your Honor.
Are you reserving time for rebuttal?
May I reserve 1 minute, Your Honor?
You may reserve 1 minute. I'll even give you 2 if you'd like.
Thank you, Your Honor. I would appreciate that.
Go ahead for the plaintiffs.
Plenty of booze, an old rickety tower, and everything went wrong. On May 24th, 2019, Sergeant Bell raced to the defendant's fraternity and discovered a scene that the defendant created. The smell of alcohol hung in the air as Sergeant Bell walked past discarded cups, past the defendant's tiki bar sitting out in the open. She saw sand on the ground, and from there a beach, and from there a crude pool that the defendant's members built. From there, a decrepit lifeguard stand that they hung above the shallow water. Sergeant Bell saw a group of the defendant's members huddled around something on the ground. And then she saw the body. She saw her body lying there, cold and wet next to that pool, sand sticking to her skin. Sergeant Bell pushed past the crowd, checked to see if the girl is still breathing, just barely. As an ambulance arrived, Sergeant Bell rushed to load the girl into it, slammed the door shut, watched as the ambulance bolted away. Look at Exhibit 13. This girl, Kay Denning, was rushed to the hospital that night. This girl, Kay Denning, was brain dead by the time she got there. Kay Denning died because the defendant fraternity ignored everything that could go wrong. Miss Denning is gone forever because an officer of the defendant's fraternity insisted that she come to that booze-soaked party, no matter her age. She's gone forever because members of the defendant's fraternity built a crude, shallow pool at that party, and then they hung that rickety tower over the shallow water, despite knowing, discussing that somebody might hang off of it, climb on it, fall off of it. Miss Denning is gone forever because of the conditions at the defendant's party, conditions that members of the defendant's fraternity gleefully created. And nothing we do here today will bring Miss Denning back. But you still have a vital job to do. It's your job to determine whether Miss Denning died as the result of negligence and whether that negligence approximately caused her death. Negligence of the defendant or of Miss Denning herself. If you find that the negligence of both parties caused Miss Denning's death, you'll be asked to assign percentages to each responsible party, explaining their relative degree of fault. You're required to make all of your findings today based on a preponderance of the evidence, meaning the greater weight and degree of credible evidence admitted at trial. Think of your job this way. Today, you're weighing evidence on a scale, with evidence in favor of Miss Denning's estate on one side and the defendant fraternity on the other. If you weigh the evidence and the scale tips even slightly, more in favor of the estate than for the defendant, even by the smallest drop of pool water, the smallest sip of keg beer, the tiniest grain of sand on a fraternity's front lawn, you must find for the estate on that issue. Let's talk first about the defendant's negligence. Negligence is the failure to use ordinary care, failing to do what a person of ordinary prudence would have done under the same or similar circumstances. You've seen over and over today that the defendant's members failed to do what ordinarily prudent people would do. There was an excessive amount of alcohol at that party. So much alcohol that Sergeant Bell could smell it hanging in the air. Mr. Dornberg himself ensured that there would be plenty of alcohol there, an unreasonable amount of alcohol. And then they just left it sitting out in the open, including at this tiki bar. Mr. Perez himself admits that no one was staffing this bar or the kegs out on the lawn. While Mr. Dornberg claims that he didn't give any alcohol to Miss Denning, he didn't have to. The fraternity left it out for guests like her. A reasonably careful person would have made sure that only people over 21 could access that alcohol, but the defendant wholly failed to do so. Although the defendant has claims that Mr. Perez kept underage people out of the fraternity's party, whatever steps he took were insufficient. Even if Mr. Perez was checking IDs at the front door, he did nothing to keep guests from coming in the back door or from simply walking up to the party on the lawn. There was no fence. And one sign hanging above the front door doesn't change any of that. Miss Denning or any of the fraternity's guests could have accessed the party exactly as Sergeant Bell did, by simply walking right in. Having somebody at the front door is a pretext. More importantly, reasonably careful people would not invite underage guests to a fraternity party, but Mr. Dornberg personally invited Miss Denning to that party, and he never bothered to ask her age. He shouted an invitation to her using this megaphone. And besides which, he texted her repeatedly throughout the night. Look at Exhibit 7. Hey, it's Andrew. Can't wait to see you at the party tonight. Are you coming to my party? Waiting. Where are you? Where are you? Come to my party. Would love to come to your party. Come to my party. I'm waiting. Are you coming? Over and over and over again, he texted her, asking her to come. And I know that the defendant has claimed that the party ended at 1 o'clock, but look what happened at 1:18. Mr. Dornberg texted her, "Screw Kit, Chris, sounds like a nag. Are you coming?" Do you believe that the party was over at 1 o'clock when Mr. Dornberg is inviting Miss Denning to come at 1:18? No. Mr. Dornberg claims that he didn't know Miss Denning's age, but the truth is he didn't want to know. He just wanted her to come to his beach party. Speaking of the beach, reasonably careful people wouldn't build the shallow, crude pool that the defendant's members built. They made a pool with tarps, and then they filled it with a modicum of water, barely 3 feet. Then they placed this rickety old chair in that water and thought it was safe because they put some sandbags on its legs. A reasonably careful person would know that this chair could still collapse. A person could still fall off of it. It was unsafe, and the defendant didn't take any reasonable steps to make it safe. They didn't put a sign on it. They didn't tape it off. They didn't put any sort of barrier to keep people from climbing on that stand. After the party was supposedly over, the defendant didn't take that stand down. They didn't empty the pool. They just left it there, waiting. Each of those acts was negligent, and each one proximately caused Miss Denning's death. An act is a proximate cause of an event when it produces the event in a natural and continuous sequence. When the event would not have occurred without the act. A proximate cause is one that a person using ordinary care would have foreseen might reasonably result in the event or some similar event. Miss Denning's death would have never occurred if the defendant and its members hadn't built that shallow pool, hadn't put the decrepit tower hanging over it, had just bothered to put a piece of tape around it saying, "Caution, don't climb on me." If they hadn't done any of those actions, Miss Denning would have never fallen off the lifeguard stand. She would have never been raced to the hospital that day. She would be with us today. Moreover, the defendant's agents foresaw this event happening, or something similar. Look at your jury instructions, page 3. An act is a proximate cause of an event when a person using ordinary care would have foreseen that the event or some similar events might reasonably result from the act. Mr. Perez himself testified today that he was worried about the rickety lifeguard stand, that he thought it might tip over because people at the party would climb on it. You heard him testify that they put the stand in the water because they thought people would fall off of it and that they wanted them to fall off into the shallow water below. That's exactly what happened. Now, defendant's counsel will claim that for some unknown reason, Ms. Denning dove into that stand. But putting aside the credibility of that claim for 1 second, somebody coming to this college party, drinking, and then diving off of the sand is exactly what the defendant fraternity should have foreseen happening. A person slipping off the sand and hurting themselves in the shallow water below is exactly what a reasonably careful person would foresee happening at this event. Mr. Perez discussed her concerns with the fraternity. In response, Mr. Dornberg made his priorities clear. He told her that if they had to worry about every little danger, they would never be able to have a party. Mr. Dornberg also made a statement after the accident. Look at Exhibit 9. He said, "We should have never built the lake or the beach. My dad warned me. I should have listened to him." Mr. Dornberg himself knew that he should have foreseen this death. But now, when the fraternity's on trial, he claims this is one big surprise? No. The dangers that the fraternity created were reasonably foreseeable, and Mr. Dornberg and the rest of the fraternity brothers ignored them. Miss Denning died as a result. Now, I wish I could tell you that your job was done, but I can't. Because in a moment, defendant's counsel will come on and will tell you that Miss Denning's death is all her fault. They'll tell you that she was drinking, that she decided to go back to the party Mr. Dornberg invited her to 7 times, that she decided to climb the rickety tower that Mr. Dornberg and the fraternity put there and then didn't put anything around, that for some unknown reason, she decided to dive off into shallow water. When they do, keep 3 things in mind. 1, the defendant bears the entire burden of proving to you beyond a preponderance of the evidence that Miss Denning's death was approximately caused by her own negligence. 2, they cannot meet that burden. And 3, even if they could, you'd then be asked to assign a percentage of fault to both the fraternity and to Miss Denning. Even if Miss Denning's actions were negligent, which they weren't, even if those negligent actions approximately caused her death, which they didn't, you can and still should hold the fraternity responsible for their role in her death. In a few moments, the court will charge you with your instructions and you'll go into a room to weigh the evidence in this case. When you do, think back on all the pieces of evidence, all the moments that the fraternity members should have foreseen the reasonably possible consequences of their actions. Every moment a reasonable person would have thought, do we need this much alcohol at this party? Or who are we inviting to this party? Can they just come in from the lawn or the back door? Or are the conditions we're creating here, this shallow pool and this stand hanging over it, remotely safe at all? Think of all those moments and weigh them against the defendant. You'll be given this form. As to question 1, write yes next to Zeta Lambda Nu fraternity, because the defendant's members ensured that there would be plenty of booze at that party, and then they invited Miss Denning repeatedly, nonetheless. As to question number 2, write 100% next to Zeta Lambda Nu fraternity, because the defendant and its members built that shallow pool. And then they hung the tower over it, and then they didn't do anything to keep people off of it, even though they knew they would be climbing on it. Hold the defendant responsible for Miss Denning's death, because its members foresaw everything that could go wrong. And then everything did.
Thank you, Mr. Stevenson. Closing argument for the defendant.
Yes, Your Honor. It wasn't a diving board. It was just a chair. Now, Zeta Lambda Nu, they threw a party on May 24th, 2019. Zeta Lambda Nu throws several parties a year with the university's permission. That party had a beach theme and some decorations. However, the May 24th party is distinguishable. Not just because it'll haunt Andrew Dornberg for the rest of his life, but because he wanted a special decoration, a lifeguard chair, and as plaintiff correctly notes, this caused some concern among his peers. But as opposing counsel would love to sweep under the rug, his peers were concerned with something specific. They were concerned that someone during the course of the party would try to climb the chair and sit on top of it. Now, this concern was foreseeable given that sitting is what a chair is for. Remember, it wasn't a diving board, it was a chair. Now, given those concerns, Zeta Lambda Nu took 2 reasonable steps to make sure that anyone that did climb this chair, anyone that did sit on this chair, would be okay, assuming Courtney Perez didn't get to them first. The first thing they did was they moved the chair out of the sand and into the water, because if anybody slipped while climbing up that chair, they would land in 3 feet of water. Next, they stabilized the frame using heavy sandbags, because if anybody managed to sit on top of that chair, the sandbags would make sure that it didn't tip over. But even if it did, it would have dumped them into 3 feet of water. And of course, opposing counsel is not going to point this out to you, but ordinary care requires that you must consider it from the position of a person under the same or similar circumstances. And perhaps opposing counsel was never in a fraternity. But after dealing with the members of Zeta Lambda Nu, I can tell you that fraternity members are not the brightest barrel in the bunch sometimes. But that doesn't mean that they don't know how to take ordinary care. It wasn't a diving board. It was a chair. Now nobody at Zeta Lambda Nu, not Andrew Dornberg, not Courtney Perez, not even the fraternity overall, nobody could have imagined that someone would not only climb to the top of that chair, but then choose to use it for an unintended purpose, to choose to stand at the top of it. And whether Miss Denning fell or dove, nobody could foresee anyone getting that high up on the chair, making their precautionary measures totally irrelevant. That risk was unforeseeable. Why? Because that's not what a chair is made for. It wasn't a diving board. It was a chair. Nobody will tell you that this was not tragic in every sense of the word. And as much as we wish we weren't, we are here in this courtroom to discuss it. And despite all of this, something needs to happen in this courtroom today. We have a job to do. Opposing counsel has a job to do. But most importantly, you jurors have a job to do. Now, as my co-counsel, Mr. Smithers, already told you way back in opening statements, we have a burden of our own because we know Zeta Lambda Nu is not the main reason, not the real reason that Kay Denning is absent from this courtroom today. Zeta Lambda Nu didn't do everything right, but that is not what the law requires. Do not get lost in the weeds of the plaintiff's closing argument. Do not think that the duty of care is so astronomically high. An ordinary person in similar circumstances, the law requires only that Zeta Lambda Nu did what's reasonable. The law calls this burden that we bear, an affirmative defense. Now, our job is not to show you that Zeta Lambda Nu is completely blameless. Our job is to show you that Zeta Lambda Nu acted reasonably, despite the distinct choice that Miss Denning made that night to stand on top of that chair. Zeta Lambda Nu, as I said, took 2 reasonable precautions to address a risk that they foresaw. but they could not foresee anyone choosing to stand on that chair. In deciding whether we have met our burden, the only question you need to ask yourself is, was it reasonable for Kay Denning to stand up at the top of that chair? Remember, it was not a diving board. It was a chair. A chair. Now, think about the witnesses you heard from today. We have met our burden because our burden is minimal. I don't know what scales opposing counsel has, but I will tell you, the scales of justice are right about here. Our burden is light. All we need to show is that by a sliver, by a feather, by one piece of paper in a 1,000-page book, Kay Denning made one mistake that we couldn't have foreseen. One mistake that was unreasonable. Opposing counsel cannot say that they have met their burden, and here is why. You first heard them call Sergeant Bell. Sergeant Bell conducted a half-baked investigation. Why? Because he is biased towards this fraternity. He has never left the University of Lone Star campus. He could never get a job anywhere else. He has never let go of being humiliated. And he is reminded of it every time he has to drive past that fraternity house, every time he has to drive past that football field. Remember, he's never been freed of that memory. But opposing counsel wants to contend that his police report is worth its weight in gold. And most importantly here, Sergeant Bell told you that she still hates the Dornbergs. Then you heard from Chris Bloom. Mr. Bloom told you that Mr. Dornberg knew how to use the chair properly. This means that Kay Denning saw how to use the chair properly. Yet for some inexplicable reason, she chose to use it for a purpose that such a chair is not intended for. But Mr. Bloom told you more. Mr. Bloom told you that Miss Denning had consumed alcohol elsewhere. And as much as opposing counsel wants to pound the table, they have no facts to pound. They have nothing else. They can try to assert by implication that Kay Denning had to have gotten alcohol. She just had to. But they're pointing at thin air. There is nothing concrete to make that point. And next, Mr. Bloom admitted that neither he nor Miss Denning were 21 years old, which means that if you look at Exhibit 1, the invitation, they knew that they weren't invited, and they tried to get into the party anyway. But most importantly, Mr. Bloom told us that Kay Denning fell headfirst in a position remarkably similar to a dive. He also told you that he didn't like Mr. Dornberg, coincidentally, just like Sergeant Bell. So where are we now? We have two plaintiff's witnesses that have both coincidentally stated that they don't like the Dornbergs, but we also have two witnesses, both Mr. Bloom and Sergeant Bell, and they both told you that Kay Denning was alone when she climbed that lifeguard chair. Then you heard from Andrew Dornberg. You heard from a man that will be permanently, emotionally scarred for life by a complete stranger. You heard that he never gave Kay Denning alcohol. But most importantly, you saw the look on his face when I asked him if he stood on that chair. Why? Because you are not supposed to stand on top of that chair. You finally heard from Courtney Perez. He was an employee of the fraternity during that party. He told you that the fraternity was aware of possible risks from that chair, but he also told you that his concerns were addressed. He told you that they moved that chair into the water and weighed it down because the fraternity was trying to avoid injuries. They cared. They cared about injuries from people slipping down the chair while trying to climb it. They cared about injuries from people tipping the chair over by sitting on it. But how can they care about something they don't know? It wasn't a diving board. It was a chair. Now you heard more from Mr. Perez. You heard that the water was about 3 feet deep, somewhere between his knee and his hip. And he told you that it provided impact cushion. He told you that Kay Denning stood on top of that chair, and unfortunately, that Kay Denning dove off of that chair. Now, opposing counsel may not like this, but of all 4 witnesses, nothing said, no facts shown, make Miss Kay Denning's decision to stand up on that chair, which is the only reason she fell off, anyone's but her own. And even if we assume that she didn't dive, even if we pretended that she fell, we would still have one question to present to you, the jury. Who made Kay Denning stand up at the top of that chair? Look back at everything you heard in this trial and realize that the answer is, unfortunately, Kay Denning. We are sad Kay Denning is gone. And we are sad that we have to be here in this courtroom talking about it. But as Mr. Smithers said, do not let a bad situation become even worse. Zeta Lambda Nu did not cause this. Zeta Lambda Nu saw reasonable, realistic problems presented to the ordinary fraternity person, and they saw that those might happen. Zeta Lambda Nu saw the chance that someone might get up on that chair and either slip going up or sit and topple it over. But Zeta Lambda Nu deliberately and specifically addressed both of those risks. The facts show that. Those facts are undisputed. Now, there's a reason your jury instructions tell you not to decide based on sympathy alone. And that reason, simply put, is because it wasn't a diving board. It was a chair. Opposing counsel, the plaintiff over there, they didn't meet their burden, and they'll never meet their burden, because no facts you've heard today, nothing they have can explain why Zeta Lambda Nu should be held liable for the distinct and individual decision of Miss Kay Denning, tragically, to stand up when she summited that lifeguard chair. She did that alone. Zeta Lambda Nu was not perfect. Neither was Kay Denning. The difference is, Zeta Lambda Nu is not more liable than she was. It wasn't a diving board. It was a chair.
Thank you. Very brief rebuttal, Mr. Stevenson.
Yes, Your Honor. This isn't about Sergeant Bell. This isn't about Chris Bloom. This is about the defendant's actions and the consequences of those actions. Now, opposing counsel told you that nobody planning a fraternity party could foresee that somebody would stand up on a lifeguard stand, cannonball into the pool, slip into the pool, fall into the pool, dive into the pool. Do you believe that? That nobody planning a fraternity party could predict that that might happen? You shouldn't, because it's not credible. Now, besides, look at your jury instructions and see that the fraternity didn't need to predict the exact event that might happen. They just needed a reasonable person just needed to foresee that the event or some similar event might reasonably occur. Someone falling off the top of a lifeguard stand isn't similar to somebody slipping off on the way up? Of course it is. The defendant fraternity and its members saw this coming. They put it there specifically because they saw this happening. They didn't take any reasonable precautions to stop it. They just wanted to have their party. Hold them liable.
Thank you. All right, I want to thank all the participants for your excellent presentations. So what we will do now is 8:30. The judges will be going to confer in a separate Zoom room. I'm sure it's going to take us at least 10 minutes. So at 8:40, please be available and back in this room, which time we will announce our decision, and then we will give some brief individual critiques on your excellent presentations. So thank you so much, and we will see you all in 10 to 15 minutes.
Thank you.
All right, I think we're just waiting for Justice Hart to join us.
I am here, and I love that Courtney Perez is a cat.
Yes. Thank you all. And first of all, I just want to say on behalf of all the judges, how much we truly admire you for persisting and doing this and competing and finding out a way to do a Zoom trial. Something I've done Zoom depots, I haven't done a trial, and it may not seem it now, but someday you'll look back on this whole year and doing a trial through video and laugh. And we just really admire you. And I can't imagine what it must be like going through law school and a pandemic. And we are just so thrilled that you're doing, not only getting through school, but participating in competitions like this. And I know my dad would be very proud of all of you. So thank you for doing that. We had a difficult decision, a very close decision, but the panel has decided that the Carrigan Cut champions are the plaintiffs team. You all did a terrific job, but the plaintiffs teams, congratulations to them. The best advocate is Nick Steverson. So congratulations to you on that. And you know, again, this is, it was an interesting experience for all of us. And what we'd like to do now is offer some relatively succinct critiques with some pointers, compliments and pointers for improvements for each of you. I'll lead off since I've done this before. But I do also want to say on behalf of my panelists that we'd be delighted to visit with any of you afterwards and go through in a little more detail. But given that it's almost 9 o'clock and we've been going since 5, I'll jump right into it. And what I'm doing is just going to go down the line and offer some comments. And first of my notes is Tyler. Tyler, your opening I thought was very logical. It was when I first saw your opening at the start, it's like, well, this is kind of clinical. And then all of you struggled with that a little bit, not a lot of emotion, but then I realized, crap, you're staring at a screen. You don't have the feel of a courtroom. So I recognize that. Your cross-examination of Dornberg I thought was outstanding. It was very logical and orderly. And so terrific job on that. I liked your use of exhibits and moving through and admitting the exhibits. Nick, a terrific job. Your closing was, I love the fact how you did what a real lawyer does. You talked about the exhibits and showed us the exhibits. You talked about the instructions, because that's what we all have to do. It's more than just our view of the evidence, but you put those pieces together, which is really what it takes to move a jury. I thought your cross-examination of Perez was probably the highlight of the night. You controlled that witness, and all of you, I think, look at that. Because I saw some of these witnesses were very cagey and didn't want to answer the questions. And Nick showed him who's boss, grabbed Perez by the collar and said, my question was this though. So that was terrific. So outstanding job. Evan, and well, both on the defendants, I have to say one thing you absolutely did better than the plaintiffs is have an overall theme. And the fact that that theme went all the way through from your opening to your closing. And that's something that is trial ad 101, and you clearly learned it. And that was terrific. Evan, particularly on your opening, I really liked how you previewed the witnesses. You told the narrative and told us what we were going to hear. Something I was a little confused by, though, when you did your direct of Perez, my notes show that you sort of seem to be supporting the plaintiff a little bit by talking about the foreseeability of someone injuring themselves through the chair. And that's a tough situation because you do want to show that they took precautions, but I recognize, but when you do that, you're sort of opening the door that you knew the damn thing was dangerous and they put it out there anyway. Okay, and then Peter, outstanding closing, really good job bringing it all together and sticking with that theme. My biggest single thing was some of the commentary that I would encourage you to refrain from. So when you started your examination of Bloom, you started off not with a question, but I heard a couple of interesting things. Making commentary like that, a lot of judges will really whack you on the head for that. And then with Dornberg, you said, let's both take a deep breath here. So, and then last thing on closing, and I think the other judges agreed with me on this, that absolutely in closing, you need to criticize the other side, talk about how they didn't do their case, but make it the other side, not opposing counsel. Several times you talked about opposing counsel didn't do X when you want to do the party. But I think all of us were left with a question that really was not answered, which is, what exactly did Zeta Lambda knew, and when did they knew it?
Well phrased.
Bad joke.
I just really enjoyed that joke. So I'm going to be very brief, and part of why I'm going to be brief is I'm going to start by saying that I hope all 8 of you, by which I mean all 4 lawyers and all 4 witnesses, might be willing to meet me in some large public open space for a cup of coffee or do a Zoom meeting, just because I don't know any of you and I would love to have an opportunity to get to know you. I think in these competitions, the witnesses often don't get the credit that they deserve, but you witnesses, I'm going to start with you. You acted your parts quite well. I thought, Alex, I'm going to start with you. You were, there was a lot that they could have challenged you with in terms of some of the testimony in the deposition, and I thought you did a really nice job of being very measured. Chris, I thought you did a really nice job of loving your friend but not being defensive. I thought that was excellent. Andrew, I mean, you're the villain in this story, frankly. or you have all the potential to be the villain in this story, and you weren't, and that was great. And Courtney, you're sort of the hero in this story, and you did a really good job of doing that. And you're just a cat, which is so weird, but but you, like, I thought you did such a good job. Like, I really tried to make it work. I really tried to check the IDs. So I thought the witnesses, I thought you challenged the lawyers to trip you up, and they mostly couldn't, which was impressive. In terms of the lawyers, I thought you all did an amazing job. Evan, I'm going to say it to you just because I've now been doing oral arguments by WebEx for 4 months. I think it's 4 months. I have not yet had an oral argument by WebEx where there was not some technological problem. And it's quite fascinating to see how lawyers handle it. And you were chill. And that's exactly what you need to do. Just be like, technology doesn't always work. I'm going to try another way and keep on going. And you found your spot and kept on moving. And that was great. And, you know, I hope you won't still be practicing in a pandemic a couple of years from now, but learning that skill of just taking the challenges as they come and moving along, that's a really important skill. So that's great. Tyler, one of my favorite thing that you did, and I'm sure there were other things, I took a silly number of notes. So there may be a ton of other things, but I thought your opening argument where you talked about the focus on what they didn't do was really right. And if this had been a real trial, like one of the things that because I'm an appellate lawyer, so I work with a factual or appellate judge, so I work with a factual record that's already done. I found myself judging all of you because I was like, oh, there's so many other facts you could just get in there. but you've got the factual record that you have, and you were making good use of them. And Tyler, I really liked your focus on like the things that the fraternity didn't do, given what they already knew were the problems. I thought that was a really good way to frame the opening argument. Nick, so Nick, I feel like you talked a lot, so I have many negative comments for you, but also many positive. So I really feel like we should get together and I could both harsh on you and compliment you. And Peter, the same thing is actually true of you. I sort of felt like Peter and Nick, you were the talkiest ones. Michael tells me I'm wrong about that, that it was actually evenly distributed, but I would love to connect with you and just kind of jab about some of what happened, but I thought you were both amazing. So
Absolutely. I'll email you tonight and we'll set that up.
great.
There is no question.
But I really, this was so impressive. You guys are all very impressive. All 8 of you, again, not just all 4.
I agree, and I don't even like cats. John?
I agree with nearly everything that's been said. Let me just say to all of you that you all have different styles, and that's because you're different people. And there's some edges you can brush up on for various purposes. But continue to be yourself. Do it your way. Be who you are when you talk. And when you talk, as best you can, and you all nearly did this pretty well, talk as if you're talking to somebody across the picnic table. And that way, I mean, that's what I call, what I think conventional wisdom calls, excuse me, it calls, well, I lost my train of thought there.
It's conversational.
Yeah, conversational is the term I was looking
for. That's what we all know we need.
I would say, Peter, you might have some of the most brushing up to do in terms of things like addressing objections and those kinds of things. I thought you really hit your stride when you got to the closing argument, which is excellent. But you know, that is one thing. And it's worth looking at yourself on tape to see these things where you're very effective and communicative and everything. But you know, you can talk to a judge and on an objection, and you say, "I think that," or "I think this." Well, the judge doesn't give a damn. What the judge cares about is what's the law, what's the rule say, you know. So I guess I would say that, and I really mean this in terms of all of you keeping your own style. Evan, you have a very nice, straightforward, factual manner. You ask excellent questions both on direct and on cross, and you keep it simple. The same with you, Tyler. You have a different style. It's kind of a Kennedy-esque style in a way, and you, to me, and but it's very effective and conversational. I mean, I think people will identify with you. And as a general rule, keep in mind that the simpler you can be when you're talking to the jury, the better, generally. Now, there's a school of thought that thinks that simplicity is on the side of the plaintiff and confusion is on the side of the defendant. And there's a certain amount of merit to that. But in general, I think the secret for you to be a successful advocate is to keep it as simple as you can be. You know, these people come in, you're out doing your opening statement, and they're sitting there, they don't know what the hell their job is, they don't know what's coming next. And so the simpler you can make the issues that they have to deal with in that opening scenario, the better. So those are my thoughts.
All right, I'm just going to confess, I am technology challenged, but I've just been asked if there's a way to communicate with me. I'm hoping that I'm sending
I can do an email introduction.
I think
I can put your email address in the chat if you'd like, if that's okay.
I don't necessarily go to all the people.
Emily, just email all 3 judges with the participants.
Did that get to you, Andrew Dornberg, who's not Andrew Dornberg? It was Andrew Dornberg who asked me, and I'll try to not dislike you, despite your very racy history.
Too kind, and I did receive it, thank you.
Okay.
Terrific. Well, I know it's been a long evening. On behalf of the Carrigan family, I want to, and CELA, I want to thank everyone for all your attention. Thank you, Justice Hart, Professor Hart, and John Purvis, one of our many distinguished alumni and top alumni award winner, well-deserved, for sharing the evening with me. And Mom, hope you're still paying attention. And I will guarantee this, tonight was far more civilized than tomorrow night's vice presidential debate will be.
Oh my goodness.
But that's setting a low bar.
And
All
Well, I know Judge Hart shares this feeling, and that is that we think, the two of us think you did a hell of a good job, Michael.
so much. Yes, Michael, you have inspired me for a decade and a half at least, and tonight was just another example.
Well, thank you for not reversing my rulings, Justice Hart. Anything else, Emily?
No, thank you to our judges and our competitors and our IT department and our student competition chairs. Like, everything was great, and I appreciate the flexibility, and I'm so glad that we were able to do this even in the middle of a pandemic.
Amen. Thank you for all your hard work to make it happen, Emily.
Thank you very
Good night,
much.
everybody. Congratulations to all of you.
Thanks, bye.
Thank you all.
Thank you.
Thank you so much.
Yes, thank you.